Welcome to a live episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
Good morning, STS Nation, and welcome to live coverage of the closing arguments at the Charlie Adelson trial. Not only do we have the live stream momentarily, you're looking at a live look at the court, but we will have analysis you will get nowhere else with the great Tim Jansen, who is in the house. Good morning to you, Tim. How are you?
Good morning. How are you, Joel?
I'm tired, but yet ready for this, ready for Monday, Tim Jansen. We had a very interesting show last night. You joined us last evening. If you haven't checked it out, there were some interesting wiretaps that we came across that really portrayed Charlie Adelson in a light that we had not seen. Tim, walk us through this morning. We're just looking at the seal of the great state of Florida inside the Leon County Courthouse, which is presided over by Judge Stephen Everett. But in about 13 minutes, he's pretty prompt. He should be walking in, and they should be getting the closing argument. So walk us through what we should be expecting this morning.
Well, first, I want to shout out to my wife. She's up north, and she's really sick, and she can't get home to me. And I can't be with her, so I just want to tell her I love her, and I hope she gets better quickly.
Oh, man. Hope you feel better. Sorry to hear that.
Yeah, she's not she got caught a bad bug, so she can't get home. It's tough for me not being able to get up to her, and she can't get to me. So I'm thinking about her and praying for her. Okay, here we go. Let's talk about this case. This whole layers thing. I think, all Georgia has to do, if she's really clever, which she is, she can just put up lines. She can start off. If I was at the airport, if they had evidence, we'd be at the airport. Arrest me or have a nice day. Who says that? The rental car hypothetical. They didn't mention my name. They don't know the whole story. The next day when you were paid, none of them were driving a Bentley. Clearly things that co-conspirators talk about. He would have no idea I had anything to do with it. Cannot have it come back to him. This is all I could come up with. I will go Nazi. You mess with my family, so help me God, Katie. I will continue to take care of you. These are all the things he said on tape. These are his own words. And then what did him and Donna say? When the bump happens, probably involves the two of us, right? The two of us, which is exactly what all the facts show. And then the most compelling and incriminating, Wendy doesn't realize how lucky she is. She doesn't know how lucky. She's not carrying the burden of what we have done, what we're going through. And then finally, I couldn't go to the funeral, even though I know who killed your husband, because I would have been uncomfortable.
So, Tim, are you suggest? First of all, this is amazing. I obviously you went back through it. Are you suggesting that she should play all these individual audio clips as we go?
Yeah, line them up. I just wrote these down in 5 minutes. In 5 minutes, it took me to write these down. You play them, and then in her rebuttal, he's going to talk about layers. What I would say, ladies and gentlemen, there's layers. There's layers of bullshit, layers of nonsense. That's all the layers there are. Turn their words around against them when they can't stand up again. It's very effective. Everybody will look at Rashbaum. He'll try to hide in the chair, and Charlie will probably fidget in the chair, and the jury will know the gig is up.
Tim, how are you so good at this sort of extemporaneous? You just throw these things out here. Is this just from years of experience? Because when you talk, I'm ready to convict. I just hope Georgia is ready to do the same.
Well, you got to be good on your feet. Trial lawyers have to be really good on their feet, and you have to know the facts, and then find your weakness of your opponent and turn it against them. This whole layers thing, I would turn that layers and said, you've heard of layers of bullshit in this courtroom. Layers and layers of bullshit. I wouldn't say bullshit. I'd say bull crap. And then I'd go through it. And I think the jury is going to be with you. I think and I think Dan's not going to like it.
Yeah, that is interesting. So let's break this down individually. Daniel Rashbaum, what did he have to do over the weekend to prepare for this morning, if anything?
Well, he's going to basically just go over the same opening statement that he had, his points. He'll probably talk about the pieces of the puzzle again. He will add in a lot of attacks on Catherine Magbanua because he wasn't sure that Magbanua had been called to the stand. If he's got some impeachment there, he'll then incorporate Pat Sanford showing even the government's own agent said that Magbanua was a liar, and the Chris Corbett said she's a liar because the phone records show she. So you can't really believe anything that Magbanua says. So when you get rid of Magbanua, what do you have? And then he's going to do his little song and dance, his extortion, and hope that someone buys it. That's what he's going to do.
And then the state, Georgia, she's tried this case before. Shout out to Robin Williams, not that Robin Williams, because that would be impossible. But thank you for becoming a YouTube member. I'd love it if it was that Robin Williams and he was just hiding on an island somewhere, but I don't think that's the case. Tim Jansen, Georgia Cappleman, what was her weekend like? This is the crescendo here. This is the moment of truth coming up.
Well, I think she's going to pinpoint all the ludicrous things he said, every incriminating statement that he made on those recordings, play them back. The defense doesn't want you to play those recordings. They don't want you to play Dolce Vita. They didn't play very many recordings, did they? Because they're all bad. She just plays those recordings, line them all up, get to the point, and say, wow, look at that, ladies and gentlemen. Those recordings are consistent with the facts in the case. They line up perfectly. And he wants you to forget those. And then he gets on the stand. He's got an answer for everything, but he can't change what he said, and he can't change what he did. He could become a new person in this courtroom when he's testifying, but he can't change what he did. And he was a conspirator to murder. He admitted paying the murderers. He didn't go to the funeral. And you hear his conversations. This cannot come back to me. And we've proven to you, ladies and gentlemen, he's a conspirator. He organized this. It's not a mistaken joke about this TV and hiring a hitman. It's what he did.
Karen with a super sticker. Thank you so much. There's this comment, Tim, from JG. I bet Charlie is regretting his life decisions. Do you think so? You've come across people like this.
Yeah.
You're a criminal defense attorney. Do you think he's regretting it, or you think he's just too much of a narcissist and he's just sitting in there thinking he's about to be acquitted?
I couldn't help but when looking at him, listening to him testifying, I know he's fighting for his life, but he looked like he really enjoyed it. He looked really comfortable in that chair. He looked like he was on like Jeopardy and waiting for someone to give him another tough question. And he was just spitting out the answers like he knew the answers. Defendants don't usually act that way on the witness stand. I'm sure he regrets it, but I don't think he's ever going to show it. And he'll never, ever admit it. Convicted or not, he will never admit it.
Let me ask you this, Tim. Should Georgia also use the fact that he was so smooth on the chair against him and say, hey, Dr. Adelson, how is it that you knew every single date, that you had an answer for every single thing from 10 years ago? It's because you rehearsed this, because this is a script, because you're an actor. Should she turn it on him in that regard?
Absolutely. She should do that in rebuttal. And remember one thing he said at Dolce Vita. He told Katie, this is all I could come up with now. Okay. Well, when you have a year and a half, now we know what else you can come with. A little more detailed explanation for everything and compare it to his testimony on the stand. I feel Georgia is going to do a great job. And it's not hard to do a great job when you have the facts on your side, right? When all the evidence lines up, when common sense lines up, and you have to believe this hokey pokey story for it not to line up, I would much rather be giving the state's closing and rebuttal than the defense's.
Paul K, look at this super sticker. Blessings on you both. Hope your wife, Tim, recovers quickly. Blessings from down under in Australia. We're so lucky to hear your opinion. This is the moment of truth. Amanda the Yahoo $5 sticker. Thank you all. Tim, just in terms of organizing this closing for both sides, but more so for the state, there's so many things she could pick and choose from. I mean, it's almost endless. How do you collate it all? How do you organize it all? How do you know where to start? How do you know where to finish?
Well, you're going to start chronologically. You got to start with the motive. A bitter divorce. You start with the bitter divorce, and then you'll go work your way backwards and go forwards. And then you want to reach your crescendo at the end. And she should say, you know what? She didn't have to. He didn't have to present any evidence. But when you do present evidence, it should be credible. It should fit the facts. And none of it fits the facts. It completely dissipates all the facts that we've introduced, which is all credible. And then in her rebuttal is when she reads those points and then talk about how in the world anybody could believe that Sigfredo and Rivera could commit this crime on their own with no money. They're like the Keystone Cops. These guys, he couldn't even find the phone number for the FBI agent. He shot the car up the first time, but we want to believe that these two guys were able to extort this multimillionaire out of $130,000 for committing a crime and killing someone he hated. Who does that? Who does that?
Doesn't make sense. Tiger Lily here. This is interesting because there's a lot of little things that a lot of people didn't catch. And this is an interesting comment. Tim, Donna said to the bump agent, I never spoke to him, the friend in Broward. This indicates she knew of him. There are little slip-ups like this. This is subtle. By the way, a little bit. Did you find your keys, Joel? No, that is why I'm not in our global headquarters. I am in Studio 1K. Have not found them. I was too tired to look for them last night. For those who didn't are not in on it, I'm blaming my kids. Lost the keys to my podcast studio, and that's why I'm coming to you from the home studio. But we'll find them. Chuck Miller with a super sticker. NJ Cool Chick, so ready for this. Can't wait to hear Tim's analysis. Justice for Dan Markel. Shaq Oatmeal, of course. Please hit the like, share, and subscribe buttons. Please do that. Tim, what are the nerves like ahead of this? When you're going into closing arguments, are you generally nervous? Are you comfortable because the job is basically done? How do you feel typically? How do you think George is feeling today?
Well, you're going to be nervous, but you're going to be prepared. You've done it a couple times in your mind. You got the key points, right? You know the key points you're going to make. You don't want to miss those, but you don't want to get to where you're reading it. You want to get where you get that flow going, and you start, and you got to believe it, and you got to show that you believe in it. Not like the defense in Murdaugh when they did that closing. That was like one of the worst I've ever seen. He didn't even believe in the things he was saying, and it became apparent he didn't believe it, and of course the jury didn't believe it either. But you are nervous because you want to. You prepared, and this is an important moment. The state. This is an important case for the state. This is the people who were basically responsible for the murder. Without them, there would not have been a murder. And you want to bring justice to those who think they can skirt the law, hide behind people, and come to the courtroom and lie. And Dan's doing the best he can. But one thing Dan knows he's going home today and tomorrow. Okay, he's going to do the best job. I imagine he's just going to repeat his opening, and he'll add a few things about Magbanua, and then he's going to say his pieces of the puzzle and the layers. He's innocent.
Yeah, I don't want to bash on Rashbaum because he's doing his job, but you think this was good or bad for his career, Tim, taking this case?
I don't know.
Yeah,
you can have really good lawyers with bad facts, and they look like bad lawyers. And you could have a really great factual case with a bad lawyer, and it makes him look like a great lawyer. You know what I'm saying?
Yeah. I bring it up because my mom last night, when I was pointing out that he's a nice guy, which he appears to be with a bad job, she said he didn't have to take the case, meaning that, he
took it he probably got paid well. The high-profile case. And a young lawyer, defense lawyer, wants to get on national TV, get exposure, and if you win the game, win the match, so called, it's just extra. And sometimes, what's the saying they say? The only bad publicity is no publicity.
Exactly.
But I don't know how he's going to. He'll go back to the Miami area. I don't know how much they're following it in Miami. Do you? Is it in the papers down there?
Not really. It's not that,
Everyone can
yeah,
be seated.
yeah, here we go, everyone. I was just going to say we're about a
Before I
minute
ran the
late.
jury instructions for
Let's
both
listen
the
in.
jurors and the parties. Did anyone have anything to raise concerning them?
Yes, Your Honor, very briefly, and I apologize for not emailing you over the weekend.
I was about to ask why this didn't happen, but go ahead.
It's a long weekend, Your Honor.
He's not happy.
So just minor, on page 2, under 3.5B, it says to be the last sentence says to be a principal, the defendant does not have to be present when the crime is committed or attempted. It is a correct statement of the law, but I wonder if we need or attempted to be consistent because we've taken out attempted in other areas.
Right. State, do you have a position concerning this edit?
No, sir.
Very well. I believe there are any attempts that are a part of the charged offenses, just completed offenses. So I will remove attempted. Is there anything else?
2 more, Your Honor. One is just a typographical. On page 4, under 3.7, in first paragraph, 3rd line down, it reads information. I think it should read indictment.
Yes.
And then lastly, on page 7, under verdict, it refers 3.12. It is the standard instruction, but it refers to lesser included. And since the parties have waived lesser included, I think perhaps the first paragraph ought to come out. And
Judge is not happy.
for the second
Well,
paragraph.
I would believe it would just read, you may find.
Tim,
the defendant
explain real
guilty as
quickly. So the
charged.
judge asked if there was
or not guilty.
any amendments, and they want to change a couple of the
Go
jury
ahead.
instructions, and he suggests he should have done it over the weekend, right?
The first
That's right.
sentence has
He's ready to
clause
go.
which
He's
reads,
got his
"Not
instructions.
execute for the highest
He wants to
offense of
move
the verdict
forward.
form."
And he doesn't like this. Now he's got to make changes. And this is his most important job, is getting the jury instructions right. And he doesn't like changes like this. This is not good lawyering. I mean, she has to do it, but it should have been done sooner.
Why did it sounded like he told them to email
State,
him
do you
over
wish to
the
be heard as to any of these
weekend.
other
Why?
No, Your Honor.
By the way, just so everyone knows,
So,
courtroom
it'll take a
audio
few
is
minutes to
out
go
of
through this,
everyone's control. It's part of the pool
which is
feed.
why I wanted you to
Hopefully
email
they
me.
raise it up.
However, we'll get
And
started as soon as this is done.
right now, this is the
Is there
highest the
anything else
level
that we
will
need to
go,
address?
because I see Trish Noonan
Judge,
asking
the
us to raise
state
the
has
level.
provided
It should get better once we're in it.
laptop for the use in the jury room. It does not have anything on it. It does not have internet access. It's available for inspection if anyone wants to do that. But it's our thought that they would be provided with the headphones that are out here. The other equipment is already back there, and this laptop for their use while reviewing the evidence.
Does the defense have a position concerning them?
No, Your Honor.
Very well. It will be sent back. Any other issues?
Nothing from the state.
I'll email you those changes, and from there, you won't need a verdict form, but we'll need 17.
Yeah, he's not happy. Got to make changes again. Jury's got to wait. She's got to make the changes. And then he's going to have to review the changes.
How long does this process take, Tim, right now?
I mean, there's not many changes, but it could take 10, 15 minutes, and you got the jury waiting. The jury instructions are the most important thing to the judge. If he screws those up, this thing can come back. He likes to have everything done, everything all organized. You all agreed to these jury instructions. You come in right when I'm on the bench and we're getting ready to bring the jury and say you got more changes. Judges don't like it. Does it happen? Yeah, it can. But the judges don't like it.
Tim, I'm so deep in this case. I actually had a dream last night that I was running around doing bad things with Charlie Adelson. Nothing crazy, but it wasn't comfortable. As you see right there, Daniel Rashbaum patting him on the shoulder.
Yeah,
He looks nervous. How's he look to you? I mean, this is the day of reckoning for him.
he's probably thinking he could have done something more. I could have said something more. I think he knows what's going to come. I think he knows what's going to happen. I don't think he's looking forward to the closings. He's thinking in his mind, God, why did I do this? And they're going to catch me. and not a good thought. That's not a good thought, right? Blinking a lot.
Yeah. And Tim, what do you, by the way, super sticker from Philly Faith? What do you say to your client? How did it go down this morning? He's brought back from the Leon County Jail. If you're his defense attorney, are you meeting him in the courtroom? Do you meet him somewhere else? What time did they meet this morning?
They could probably meet down. They got a little cell downstairs. He could have met with him downstairs beforehand. Um, they'll make it. They'll make that possible for him. But right now Daniel's focusing on his closing statement. That's what he's focusing. That's why he's got the other lawyer doing the jury instructions. He can't be bogged down in that right now. He's got to be focusing on his strategy, what he's going to say, how he's going to say it, what exhibits he's going to play, how he's going to respond to the government. He's got to be able to respond. So he's got to have his laid out closing, but he's going to have room to clean up some of the stuff the state says. I haven't heard the judge ask how much time each one needs or how much it's going to be so they can make it fair. He may do that right before they start.
In terms of how much they each get for the closing, does it have to be, is there a laid out amount of time that the judge gives you?
No, the judge will ask you how much time do you want. And some judges are more, they think brevity is better, but it is a murder trial. So you can't really tell them they can't. It's been a 2-week trial. So it's going to let them give some deference. I would imagine at least an hour and a half. I would think maybe more because, you're going back 9 years in time with a lot of some exhibits and phone calls. So he would have done that usually by now, asking how long they're going to take.
Look at Judge Everett. He's just no nonsense. Chip Kurth, love Judge Everett. It looks like he's actually literally working on the instructions right now. I don't know if he's the one. Tim, is he the one that goes in there and makes these changes?
He will. I thought he wrote the changes and gave them to his judicial assistant to make the changes. Maybe he's doing some other emails right now, or maybe he's reviewing her changes. He may be looking at the verdict form, make sure it's correct, which I'm sure he's done that all over the week. He did that all on Friday. This is the major thing that they got to get right. And if it's not right, it could come back on appeal.
And Tim, someone asked, and I lost a comment, the defense is desperate, it shows here, but there was another comment asking or suggesting that they just did this on purpose. However, the jurors haven't seen the instructions yet. They were saying, are they doing this on purpose to basically throw the jurors off, to confuse them a little bit, because the instructions would now be a little different, but they haven't seen the instructions yet.
Yeah, they haven't even seen them yet. The jury doesn't even know why they're waiting. The jury just, hopefully all of them are there. But I don't think the jury doesn't know anything about the jury instructions. Maybe the ones that have been jurors and foremen, but they don't know there's been a change.
And Tim, we're talking about the defense, the state, the judge, but what about the jurors? I have never served on a criminal trial. You've obviously defended people and you've spoken, I imagine, to jurors after the fact. Right. What do you think is going through their mind this morning, knowing that they're about to hear closing arguments? How seriously do they take it? Because if they convict them, he's going away for life.
Now, remember, they have not been able to talk about the case yet. They can't do any. They can't talk with other jurors. They can't talk to the spouses. The only time they can talk about the case is after they begin deliberations. So they've got all this information. They're excited about the closing arguments too. Some maybe have already made their mind up. Maybe some haven't. Some are waiting for the whole thing put a ribbon on it for like the state does. And others might say, I don't believe anything. I'm going to hold out. So they're nervous, but they're anticipating, they know it's going to be a good day because it's not going to be a monotonous witness. It's going to be them arguing to them the facts, and then they know they're going to make the decision.
Scott says, let's hope Georgia brings an A+ presentation as they need it. Now, I don't want to be sexist in any way, but Daniel Rashbaum wearing a similar suit to the ones we've seen. However, Georgia Cappleman and I believe a bright pinkish toned business suit.
I wish they were paying to Georgia and Sarah because I could tell who's doing the first closing, I can look at them and you can see who's looking at their notes, because one will be looking down at their stuff, the other will be just, assisting, and they're not panning on them. I like to see which one's going to do it.
Hopefully, the Court TV pool cameraman heard you on that. This is from Julia something. I can't even attempt to pronounce it. STS Nation, wonderful community, and Tim has been fantastic. Irreplaceable. Tim Jansen, super sticker. Thank you.
The state goes first, then the defense, then the state gets a rebuttal. They both get equal time. So depending how much time the state uses in their first part, the judge will subtract that from their total time in rebuttal. They usually leave 15, 20 minutes for rebuttal. So that's not difficult.
V with a super sticker. He used code during cross-examination describing a phone conversation with who's CM, Tim? My mind is shot. Where he referred to marijuana.
Was that guy that was calling up about getting marijuana or something?
Yeah, this is a bonsai tree. Yeah, I don't remember CM's name. But anyway, Carm commented on this. Someone asked Carm if they like bonsai trees last night. Tim, this is your old judge he dealt with. Hankinson would have told the defense to pound sand. What would he have done? He's an old timer. He would have been upset, correct?
He would not have taken kindly to their changes to the jury instruction. He would have dealt with them severely, but he would have made the changes, because he's smart enough to know if they're not correct, that it could come back. And the one thing you want to have is a fair trial, and you want to preserve a fair trial for both sides.
Started with bringing in the jurors,
So now they got the instructions.
And you see George on the left in the pinkish. You see Sarah Dugan on the right in the gray suit.
She's on her phone, so it looks like George is going to do it.
Yeah, and they are bringing in the jurors for closing arguments. You see Charlie Adelson. The moment of truth has arrived. Good Tuesday morning from New Zealand, where it is the future. There's a day ahead. By the way, someone asked us here. It is 8:58 a.m. Eastern Standard Time in Tallahassee, Florida. Daniel Rashbaum approaching the bench. Once they begin to speak, we're going to listen in. And
he's not going to look good with it during rebuttal. I hope they show his face in rebuttal when whoever does rebuttal for the state. He's not going to look good.
He just took a deep breath right there, and he's kind of stroking the chin hairs that he doesn't have on his cleanly shaved face. And there's co-counsel. After all this time, I still don't even know what her name is, to be honest. And there's
something used, and they're talking about her Hermes belt she was wearing in court today.
And we're looking at a wide shot of the court. The judge is not there. Rashbaum is literally pacing right now.
Yeah.
And you see George and Sarah very calm. Obviously, people are in the gallery.
I wonder who Dan's texting right now.
It's probably his wife. He's probably yelling at him for something, would be my guess.
She is probably saying, "Good luck, honey. You did a great job." And that feels good.
And don't forget to bring milk and toilet paper home.
Exactly.
Don't forget to stop. You're still my husband, and you will do as I say. Maria 59 became a YouTube member. Daniel Rashbaum. It's interesting. I bumped into him on the street maybe last Thursday. He was walking out. We were all going to grab lunch. I said, "Enjoy lunch," and he said to me, "I don't eat during criminal cases. I don't eat." So I've seen him drinking water. Diane seems to agree with me. Charlie looks stressed this morning. I'm nervous. I mean, let's keep in mind, by the way, and I think this is very important. This is all about Dan Markel. I had Katie Kool-Lady on the show last night. She went to, there's a memorial bench for Dan Markel in Tallahassee. She went there to pay respects. There was a act of kindness in memory of Dan yesterday. It's all about Dan Markel. We're talking about the high drama here today, but that's what it's all about. And someone's asking me what I'm drinking. grapefruit juice. Grapefruit juice. I'm not a big coffee drinker, and if I do, I'll be wired. So better to have something like this.
You see the comment that Dan Abrams took your keys? That's hilarious.
Well, that came up because we had Tim on. We beat Law and Crime by about 10,000 views on the cross exam, which we will do again today. So I was poking fun at Dan Abrams, which I shouldn't. That'll come back to haunt me. But he's actually a good guy. I've worked for Dan Abrams, and guy's very brilliant mind, smart business guy too.
So you'll see today, Joel, a lot of the agents, Pat Sanford's in the gallery. A lot of the agents in the case will come and now sit in the gallery in support. And they can do that in support of Georgia, letting the jury know that they're supporting her, letting them see them again being here, reminding them. It's a big advantage for the state when that happens.
Yeah, that's really interesting because I didn't see that. And Mish, coming to us from Cape Town, South Africa. I wonder if Chucky has anyone there supporting him today. Very doubtful that we'll see anyone. Don't you think, Tim?
Yeah, doubtful. We won't know. It could be anybody that could be there support, but I haven't seen him turn around talking to anyone.
Yeah. And how does that play to the jury, Tim? That they look over. They were looking at me in the gallery and I was sitting, not at me, but I was sitting right behind Ruth and Phil and Shelley Markell, and they were looking over periodically. But how much does it play on them to know that he has no one there to support him?
Well, that does play. I've been in a courtroom where you have the whole defense has people, and the state has nobody, and that puts pressure on the judges. It does put pressure on the jury. You could have mother and father, depending on the kind of case. There's Jason Newland. He actually has a coat on today. Tie. Still no tie. He's the investigator for the state attorney's office.
Okay, because he was coming in periodically last week to help with all sorts of things. Tim, how well respected is Georgia among her peers and law enforcement officials?
She is probably one of the top in the office, and been around a long time.
Kathy Rabb says Charlie looks like he's going to be sick. Charlie looks like he didn't sleep at all over the weekend. And this is true. I would consider it a quasi nightmare that I was running around with Charlie Adelson in my dreams last night. By the way, part of that dream, my hair was falling out. So any dream interpreters, please let me know. Looks like Charlie's clinging to his hairline, unlike Tim Jansen. Jessica K, member for 8 months. Joel, curious to see if you'll have the trial withdrawal after this. I didn't understand this phenomenon until my first invested trial watch, which was Murdoch. It's possible. I mean, there's no doubt that there's an adrenaline rush and a dramatic flair to these trials. And when it's done, I think that most people, probably miss the adrenaline of it. Christina, super sticker 499. Only Charlie knows what's going on. Look at that, looking straight down. Only he knows what's going on between those ears, but
he's about to cry.
Yeah, he looks tense, man. He looks tense. And I can't blame him because if I was facing life in prison, we're not at the reading of the verdict, but we are standing for the jurors. Here we go.
Everyone can be seated. You can pass those out. For everyone in the gallery, I just wanted to give a reminder once again, as the closing arguments are taking place, do not make any gestures, do not shake your head that you're in agreement or disagreement. Please silence your devices, and also as well, do not have any cameras that are pointed at either the jury or the litigants.
Yeah, he's going to read an instruction for the jury, so.
By the way, Tim, this is interesting. Some Bundy data said that civil suits could follow. I mean, how deep are the Adelsons in this, even if there was, and I think it's a small chance, even if there was some sort of acquittal, the Adelsons are going to be mired in this for years to come, correct?
Yeah, and remember, the standard of proof in a civil case is much less than it is in a criminal case, So that's why civil suits a lot of times are more successful than criminal cases.
Pretty lucky tarot. Charlie said what we were up to, a slip that Georgia missed on the stand during back and forth during cross. There are a lot of these little things, but just because Georgia missed it doesn't necessarily mean the jurors missed it. Hart Matterhorn. Does anyone know if Charlie bought or increased his life insurance after he was supposedly extorted? Interesting question, right, Tim?
Yeah. I don't think he was in fear of his life.
Yeah, I don't think he raised his life insurance.
He paid the people that committed the crime. So
look at this. Bling is the new black. I'm on a cruise, but it's a sea day, so I'm here with you all. Enjoy the cruise. Hope the seas aren't rough. It's amazing where people are watching from. Where is that cruise? Let us know. Oh, man. The drama is high. Let me tell you, the bailiffs are excellent in the courtroom, but there are a bunch of bailiffs, sheriffs, deputies around that courtroom. There's about 4 or 5, and they keep a very close watch, making sure that people aren't taking pictures, aren't audio recording, things of that nature. But the gallery obviously knows what's at stake here today. I'd like to get a full wide shot of the gallery and see how look at Charlie. Look at Charlie right there. That says it all. Debbie D 1999 super sticker. I mean, this change of jury instructions is just in an odd way torturing Charlie, because now this is dragging out closing arguments. Here we go.
here comes the jury.
Rising for the jury.
Everyone can be seated.
Now the judge is going to read line by line, word by word for a while. So,
How long are these instructions generally?
15
Members of the
minutes.
jury, good morning.
Okay. Let's listen in.
Now that the evidence has closed in the case, I am going to be giving you your instructions on the law itself. A copy of the jury instructions that I will be reading to you has been placed in your chairs. If you wish to follow along as I read to you, that is certainly your choice. If you just wish to listen as I read it out loud, you may do so as well.
30 minutes.
After these instructions have been given, the attorneys are going to give you their closing arguments. Let's get started at header 3.1, Introduction to Final Instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Charles Adelson, the defendant in this case, has been accused of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. Charles Adelson is accused of first-degree murder in count 1 of the indictment. I will now instruct you on the circumstances that must be proved before Charles Adelson may be found guilty of first-degree murder. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Charles Adelson. Element 3, there was a premeditated killing of Daniel Markel. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If the defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the defendant had a conscious intent that the criminal act be done, and the defendant did some act or said some word which was intended to, and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed. If the defendant paid or promised to pay another person or persons to commit a crime, the defendant is a principal and must be treated as if he had done all of the things the person who was promised or received the money did if the defendant had a conscious intent that the criminal act be done, and he made or promised the payment in exchange for the commission or promised to commit the crime or to help commit the crime, and the crime was committed by Sigfredo Garcia and or Luis Rivera. To be a principal, the defendant does not have to be present when the crime is committed. To prove the crime of criminal conspiracy, the state must prove the following two elements beyond a reasonable doubt. The intent of Charles Adelson was that the offense of first-degree murder would be committed. In order to carry out the intent, Charles Adelson agreed, conspired, combined, or confederated with Catherine Magbanua and or other co-conspirators to cause the first-degree murder to be committed either by them or one of them or by some other person. It is not necessary that the agreement, conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that words pass between the conspirators. It is not necessary that the defendant do any act in furtherance of the offense conspired. To prove the crime of criminal solicitation, the state must prove the following two elements beyond a reasonable doubt. Element 1. Charles Adelson solicited Catherine Magbanua, Sigfredo Garcia, and or Luis Rivera to commit first-degree murder. Element 2. During the solicitation, Charles Adelson commanded, encouraged, hired, or requested Catherine Magbanua, Sigfredo Garcia, and or Luis Rivera to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions. To solicit means to ask earnestly or to try to induce another person to engage in specific conduct. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get this witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like any other witness, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime, has been promised immunity from prosecution, or hopes to gain more favorable treatment in her own case, may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. Number 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It will be my job to determine a proper sentence if the defendant is found guilty. Number 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. You may find the defendant guilty as charged or not guilty. If you return a verdict of guilty, it should be for the offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. And there is actually only one verdict form because we're not going to introduce chaos into the case, but I will read it to you now. State of Florida versus Charles Adelson, case number 2016 CF 3036B. We, the jury, find as follows as to count 1 of the indictment, first-degree murder. Check only one letter choice as to this count. Option A, the defendant is guilty of first-degree murder. Option B, the defendant is not guilty as to count 1. Count 2. We, the jury, find as follows as to count 2 of the indictment, conspiracy to commit first-degree murder. Check only one letter choice as to this count. Option A, the defendant is guilty of conspiracy to commit first-degree murder. Option B, the defendant is not guilty as to count 2. Count 3. We, the jury, find as follows as to count 3 of the indictment. Solicitation to commit first-degree murder. Check only one letter choice as to this count. Option A, the defendant is guilty of solicitation to commit first-degree murder. Option B, the defendant is not guilty as to count 3. And then is to be signed.
That's Tamara Demko in front of Pat Sanford, who's Dan Markel's Harvard Law School friend. So Dan's
Both the
family and
state
friends in
and the
full
defendant
court.
have now rested their cases.
George has got her notebook, so
The
she's going
attorneys
to
will now
close.
present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Is the state prepared to give its closing?
Yes, Your Honor.
You may proceed.
May it please the court.
Let's hope they play some charts and graphs and to emphasize the point she's going to make rather than just reading it. Hopefully Sarah's got the thing ready to go. It looks like she's got something in front of her up.
Yeah, she's ready to face the jury here. Closings coming in the Charlie Adelson trial. The state to go first, the defense, and then a rebuttal. Here we go.
In jury selection, we talked about the burden of proof and how it was my burden to prove this case to you beyond a reasonable doubt through evidence. And generally speaking, the defense's job is to poke holes in the evidence and argue that it falls short of meeting that high burden. And we also learned at jury selection that the defense does not have to prove anything. But sometimes if the law enforcement investigation is so thorough and so compelling that there's really no way to poke holes in the evidence, he has to basically admit his own words, his own text messages. That stuff is undeniable, right? And those things prove that he was in cahoots with Catherine McBanois in 2013, through the murder in 2014, and all the way up until her arrest in October of 2016. He knows he can't deny that he paid the killers because of this bizarre practice he had of stapling his money. So sometimes when a defendant can't attack the facts or the law, they instead try to explain it away by saying, you can't trust what you're seeing. It's not what it appears to be. It's actually something else entirely. Often, as in this case, the individual explanation, so when you zoom in on one piece of evidence with its attached explanation, can be like, maybe. But when you zoom out and you add all these things together, this explanation, and this explanation, and this explanation, this coincidence, and this coincidence, and this coincidence, it starts making less and less sense. It starts being less and less reasonable. And when you zoom out from the defense's theory, it's really unreasonable, right? Because to find it reasonable, you have to buy a lot of things that he's selling. The most obvious of which is that because Sigfredo Garcia hated him, he and Rivera traveled to Tallahassee twice to kill someone he hated in hopes that he would give them money for it on the back end. Please think about that. To hit this defendant where it hurts, these two dudes with no connection at all to Dan Markel and without 2 nickels to rub together, rented a car and paid for gas to come to Tallahassee and stay in a hotel twice in order to kill someone that this defendant hated, to harm him. And for what? To maybe get money. Maybe he just turns him in for murder. Why not just kill and rob him if what you're after is money and there's no hired hit? Why not just kill and rob him if your motive is, we hate him? Then the bad guys don't even have any contact with him, according to his own story. They didn't threaten him. They did not beat him into submission. Instead, they sent his own girlfriend to extort him on their behalf. And without any actual contact from the bad guys, the defendant just opened up his safe and handed over his beloved money that he had saved his entire life since he was a child. He just handed it over. Take it all. And when that amount wasn't sufficient, these stone cold murdering gangsters let the defendant go on a payment plan to give him the rest of the money. They let Catherine McVanois skim off the top each month. And never, over the next 2 years that he was being extorted monthly, these gangsters, remember that money doesn't go to the principal, that $3,000 a month. They never show up to demand the remaining $195,000 that this defendant has agreed to pay them. Then you also need to find reasonable that over the 2 years of this supposed extortion layaway plan, that the defendant continued to do what? Send these kissy faces and love texts to Catherine McVanois. He's sending these messages to a woman who got him into this mess, and he says he didn't suspect she was involved. What? What do we know about this man? He didn't suspect she was involved. She's taking the money. He's never even heard from the bad guys. He didn't see it that way, that she got him into this mess. They grew closer after she began extorting him for $3,000 a month. Meanwhile, the defendant and Catherine McVanois break up. She continues to maintain her direct and indirect contact with Sigfredo Garcia, the man who's extorting him, the man who murdered his former brother-in-law in cold blood. But he sees her as a friend. The kissy faces and the I love yous continue. Even after Catherine McVanois got back together with the man who executed Dan Markel, the father of his young nephews, and a guy who's actively extorting him, this defendant continued to reach out to her over and over again to offer her favors and gifts, including a birthday gift for Garcia, and to tell her he loves her and how lucky he is to have her in his life. Lucky? Next, to find a reasonable doubt here, you have to find it reasonable that the defendant never texted or talked about this first layer of extortion. Why? According to him, because Catherine McVanois said, let's never talk about this. So they didn't. Then you have to believe he never reported or revealed this information to law enforcement out of fear of the gangsters. And finally, you have to believe that this living in fear of death by gang members over 2 years didn't cause a change in his general demeanor that his friends noticed, but later the bump from law enforcement did. He says that's because, well, I became worried that I might be falsely arrested. So I wasn't a hot mess when I was being extorted by gang members and threatened to be killed and my whole family killed. But I became a hot mess when I started to get worried that the cops might be getting closer. And I have no real way of knowing if all this stuff sounds ridiculous to you, if it sounds reasonable to you, or if y'all just heard so much stuff that you're totally confused and can't even remember what the evidence in the case showed. But they only need to get one of you confused enough to derail this whole thing, right? So I've got to go through each thing with you. Your verdict has to be unanimous. So I want to go through the testimony, I want to review the evidence, and I want to spend a little bit more time talking about this multitude of explanations the defense has offered in an effort to really turn each piece of evidence on its head. This is Dan Markel. He is the victim in this case. A brilliant lawyer, a funny guy, a son, a colleague, a brother, a mentor, and a friend. but most of all, a father. A dedicated and loving father whose downfall was brought about by the fact that his number one priority was maximizing his access to those two little boys in the wake of a bitter divorce from their mother. And despite the defense's efforts to characterize their client as the real victim here, Dan Markel remains the only victim in this case. The only thing he was guilty of is fighting like hell for those kids. And he lost. He didn't lose in court, but he lost. This is what he looked like before this defendant hired a hitman to kill him. And this is what he looked like afterwards. The evidence has shown that on July 18, 2014, this brilliant man was gunned down in broad daylight in the driveway of his own home. His horrific death ultimately set police down two separate paths following the two most promising leads they had. The first was to chase down that Prius that Mr. Geiger saw fleeing the crime scene. And we'll examine those efforts in detail. The second path was to ask, as we would in any murder investigation, who might want to have done this? Who would want Dan Markel dead? And within 1 hour of the shooting, before Professor Markel was even pronounced dead, this path was already pointing to the defendant. When his sister revealed to law enforcement that her family hated Dan Markel and that her brother, Charlie, had joked about hiring a hitman to kill him. And this trash talk, of course, would be meaningless had he not been killed by a hitman. So who did it appear had a motive to want Dan Markel dead? His own family. And what offense had Mr. Markel committed against these people? Refusing to let his children be taken away from him? Objecting to them disparaging him to his kids? The evidence has shown that the Adelson family was all about psychological warfare. And when all else failed, they were willing to go even further to win. I want to examine this motive in more detail and look at exactly how it's attributable to this defendant. Despite the defense efforts to minimize this, it's really clear that the divorce between Wendy and Danny was a particularly nasty one. They fought over everything, all the way from the children down to the bicycle and the tennis racket. In January of 2013, Wendy Adelson filed a motion to allow her to relocate to South Florida with the kids. They were 2 and 3 at that time. As one basis for this request, Wendy cites the wife's parents reside in Coral Springs and the wife's brother resides 20 minutes away. The children are very close to the wife's parents. Wendy Adelson also alleges in this filing that the husband has also created a hostile work environment for the wife at FSU School of Law. Wendy Adelson viewed herself as stuck in Tallahassee, a characterization which she now denies, but one which was used to describe her situation by Jeffrey Lacasse on the witness stand and also in her own pleadings in these divorce filings. In Markel's answer on page 80, he seeks continued equal time sharing in Tallahassee. He seeks sole parental responsibility on issues related to the education, religion, and medical upbringing of the kids. Then we go to this May email from Donna Adelson to Wendy. These emails are offered as examples of how invested Donna Adelson was in this litigation and in Wendy's life in general. They reveal that relocation was a huge priority for Donna and that it was also a high priority for Wendy, Harvey, and the defendant as well. Wendy testified that her mom really wasn't that involved in her divorce proceedings. Again, these emails prove the opposite was true. On May 3rd, 2013, this email references Dan's divorce filing as, quote, his 23-page rant. She then crystallizes the importance of relocation, stating, the most important part of your divorce is relocation, in bold. I sincerely hope that your attorney understands this is your, all caps, non-negotiable. She needs to hear from you how serious you are about this and how it will benefit the children with a close-knit family support system, as well as your significantly better paying job. But on June 21st, 2013, Wendy's motion to relocate was denied by the court, with the court finding that the wife has not met her burden of proof that a relocation is in the best interest of the minor children. Like the heroine in her book, Wendy and the boys were officially stuck in this small stop on the way to what we had previously known as civilization. Wendy worked hard to try to convince you that none of this was a very big deal to her, her mother, or her brother. And she said she was expecting to win everything in the divorce. She was expecting Danny to lose everything in the divorce. She was partly right. Danny did end up losing everything, but not in court. She had already lost relocation, and her attorney had to get off the case as a result of whatever Danny was filing in court. And he was poised to really take her through the ringer with this grandma motion, the fraud allegation, and the contempt motion that was all pending. Even if he wasn't going to be successful, folks, it was going to be a very unpleasant ride for Wendy Adelson. But as we have learned, Jibbers hadn't beaten the Adelson family yet. On the stand, Wendy Adelson suggested that relocation was not a big issue for her. It was just suggested by a friend, but the other evidence in the case suggests the opposite. Jeffrey Lacasse said she was a complete mess over the litigation, especially the relocation. She wrote a book about a human rights attorney who was stuck in a small town in the Florida Panhandle because of her hapless Canadian professor husband's job at NFSU. And maybe most importantly, Wendy filed this motion for relocation. Her lawyer didn't file it without her knowing. Was the motion doomed from the start? Wendy clearly hoped not. But there were other ways to skin the cat. Here's a June email from Donna to Wendy. In response to the court order denying relocation, Donna emails Wendy, quote, it's time for action. It's time to take control of your life and not let Jibbers think he's won anything by having you remain in Tallahassee, 8 hours away from the only family you have. Let's show this F blank, 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 what will make him absolutely miserable. And later, the rest of your life, and consequently, Dad's, mine, and yes, even Charlie's, will be affected by how well you can perform/act before July 31st. You can be a good actress when you want to. I've seen you in action. You need to put on the performance of your life. Jibbers hasn't beaten the Adelson family yet. Then on June 25th, this is continued, that same email, we get a plan of action. Take a photo of the boys dressed nicely, standing at the front door by the sign of a Tallahassee church. They're Jewish, remember? Then change your Facebook status to this one so everyone will see this. Perhaps a line under the photo with "New beginnings in Tallahassee" might be nice. How happy do you think he will be? Make arrangements to get the boys caught up with a private tutor at the Teenage Catholic Church who will come to the house to teach the young men about Jesus. If you don't have time to arrange this, I'll be happy to do it for you. Let Jibbers know that your children will be baptized in the Catholic Church, and you'll certainly invite him to the event. I've already checked this out, and the baptism can be arranged within 2 weeks. We can send out evites to Jibbers, his parents, sister, and anyone else you want to invite. 4, I'm looking into summer camp programs for the boys. We will pay for it, even if the boys end up only going for the few days that they're in Tallahassee with you. 5, register them for toddler classes at the church. I've looked into this too. Even if they don't actually go, we can show Gibbers that they are enrolled for the fall semester. And you cannot tell anyone this is an act. Take control from him. Get to him psychologically. He's going to want you to stop this. You have one final opportunity to make him angry. We want him ticked off so he realizes that he could lose control over his kids. We plan to make a financial offer to him to allow this relocation. You need to work this plan and we'll help you through it so that it may affect how much we offer him. Maybe he's willing to let you relocate if he knew his children could attend this private Hebrew academy. Or perhaps he'd like them to invite him to a Christmas party at their other Sunday school. Let's get this going now. I know you would never want to think that you didn't do absolutely everything you could to come down to your family. Dad and I have changed our lives this year to support you and assist you and the boys in every possible way. Charlie has accepted the loss in the office business income for us to do this because he loves you and wants only the best possible future for you. It's time for you to show us that you can put on the performance of your life for the next few weeks. And then on June 27th, she follows up with another email along the same lines, criticizing the judge and Wendy's attorney and adding, obviously the court isn't out to help you. It's clear since Judge Hobbs' last ruling that she could care less about anything you have to say on your behalf. You need to help yourself. You know, Wendy, most of the wars that have been fought for the last couple of thousand years have been fought over religion. These emails are such telling glimpses into the family dynamics behind this murder. This email is just an example of how relentless Donna Adelson was. And it's clear from these emails that she's conferring with the defendant on these plans that she's proposing. Charlie brought up a good point when he said that Americans were dropped behind enemy lines during World War II wearing Nazi uniforms to get what they wanted. They had a job to get done and they did what they needed to accomplish it. You have a job to get done in a very short time frame to accomplish it. If you dressed the kids up in Hitler youth uniforms and brought them down here, I could care less if it was an act of defiance that would show Gibbers that he's not in control. Why not stand up to this fucker? Why not fight? That's all this is, Wendy, an act of defiance that will put a scare into this jackass. It will infuriate him. You need to see the big picture. You need to look into the future of what a life without your only family nearby teaching in Tallahassee with Danny always in the picture will give you. It's not a pretty picture. Not everything one has to do in life is comfortable or easy. The extremism that Gibbers is already teaching the boys is nothing more than brainwashing. Religion is brainwashing, control of the masses. I don't think you realize the type of offer we're considering. We're planning on you, Charlie, Dad, and I going as high as equal parts in a $1 million offer. That's $333,000 from each of us. We're a team. We can't do this without your help. You've already lost relocation according to the legal system. Well, it is about winning and losing. We're trying to get a win. You deserve it. You deserve so much more than a life without family teaching in Tallahassee. Even though the divorce was final on July 31st, 2013, the anger and bitterness associated with this split was still festering. Litigation continued and even increased as both parties filed motions over the next several months alleging that the other was violating the marital settlement agreement, and both parties seeking to have the other side held in contempt of court. In October of 2013, Wendy filed a motion to enforce the marital settlement agreement and have Dan held in contempt. And Dan was hearing, and the defendant was hearing about all of this as it went on from his mother, as indicated in the emails and in the text messages shown here as well. Here she's telling him how terrible things are for Wendy and how it's negatively affecting his dad's health. Then later that month, when Wendy was about to make the second dumbest mistake of her life after marrying Dan Markel by buying a house in Tallahassee, Charlie says Wendy probably hasn't mentioned it to him because it's stupid. And then after he gets Wendy to pull the plug on the house, he's praised as the miracle worker that solved this problem. This text was sent on Halloween of 2013, the very day that Catherine McDaniel testified this defendant broached the subject to her of, hey, do you know anybody that could rough somebody up? The defendant was hearing about Wendy's situation regularly from Donna. Here we see Donna telling the defendant how angry at Wendy's attorney and stressed out Wendy is. That's on February 15th of 2014. And here's another text from Donna Adelson to Charlie Adelson 4 days later, discussing the details of Danny's actions and expressing how much she hates him. Here on March 4th, 2014, we have Donna planning to speak in private with the defendant while she's at the rest stop in Gainesville. She asks him to delete this message after he reads it. Although he's not with Harvey, and Harvey nor his birthday are mentioned in this text message. All that's mentioned in this text message is, I'm going to pull over at a rest stop and talk to you in private. This is the grandma motion. On March 26, 2014, less than 4 months prior to this murder, the defendant files his grandma motion, the counter motion for enforcement of marital settlement agreement on parenting issues, and motion for contempt and sanctions. Again, alleging that Wendy is not facilitating communication between he and the kids and getting after Donna personally. In this filing, Dan Markel alleges that on 3 separate occasions in November of 2013, the children informed him of their maternal grandmother, Donna Adelson, disparaging him. The boys indicate that, quote, Grandma says you're stupid. She says you are trying to take her sunshines away from her. And quote, Grandma says she hates you. Dan Markel requests the court, quote, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children, and to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father. Contrary to what Wendy Adelson told us, we learned this issue was taken seriously by both sides, and that Dan Markel was particularly hot at the time of his death because of some recent issues that were going on. So to the extent that there was any banana bread peace offering made, it apparently fell short of diffusing the issues within this family. This situation was a pressure cooker, and it was about to blow. As we learned, this grandma motion was never decided by the court because Dan Markel was murdered before it could be heard. Whether or not that is a coincidence in timing is up to you all to decide. Wendy told you that she and Dan were getting along pretty well at the time leading up, or the weeks leading up to his murder. But this assertion does not fit with the rest of the evidence in this case. In fact, her own court filings are completely contrary to that assertion. In addition, her boyfriend at the time, Jeffrey Lacasse, told you all that she took all of this very seriously, that she became upset every time there was a filing, and that her behavior became increasingly emotional and erratic as the time led closer and closer up to what ultimately was the murder day. According to Lacoste, she was especially concerned about the relocation issue. And Stephen Webster, he was Professor Markel's attorney, testified, told us that Markel was irate at the time of his death over two issues. The first being Wendy enrolling one of the kids in a school without consulting him, and the second one being him overhearing Donna Adelson refer to him as stupid on a recent Skype visit that he had with the boys. So this was far from the peaceful situation that Wendy was trying to sell you. Why was she trying to sell you that? Was she trying to protect her brother? She even told law enforcement at her interview on the day of the murder that she wanted everyone held accountable for this to the fullest extent of the law, unless it was her family. The defense seems to be telling you the litigation between Danny and Wendy was not a very big deal because minimizing the litigation minimizes the motive for the Adelson family to want Dan Markel dead. They even called Wendy's attorney to tell you that relocation was a lost cause. But what she actually said was, yes, I lose most of these motions, but in this case, I actually thought there was a chance because of some of the surrounding circumstances. Then I thought, well, maybe they called her to say the divorce was routine, but what she actually said was this case was odd. That was her word, mainly because Dan Markel came after her personally, forcing her to withdraw from the case, which had never happened before. So what her testimony proved was that this was not a routine, run-of-the-mill divorce proceeding. It was one of her more difficult cases. And she didn't even have Donna in her ear like the defendant did. So the motive was clearly there. The question then becomes, was the defendant successful in distancing himself from that motive in your eyes as jurors? He says that the litigation had no impact on his life. The emails suggest otherwise. He's included on these texts. He's all over the wiretap, meddling in Wendy's life with Donna. Could the defendant have cared enough about his sister's marital problems to commit murder? Maybe, maybe not. But if he didn't, his mom certainly cared enough for both of them. And she was in his ear all the time. In defendant's own words, you can't have a miserable mom. To illustrate this point, I refer you back to the emails and to that phone call that I played that happened before the bump, where Donna and the defendant are discussing this boyfriend of Wendy's at that time, Dave. This call, along with the call about Wendy taking a particular job, which is also on that same exhibit, I think it states 130, was offered as examples to show you how the dynamics work in this family. Wendy appears to be the weakling of the pack. She needs to be protected. She needs to be helped. She needs to be coddled. She needs to be saved by Donna and the defendant. Donna is the overbearing matriarch who nags everyone to death about whatever it is that's currently on her. I call it the wheel. The wheel's turning all the time, right? And Wendy getting away from Dan Markel and moving to South Florida was number one on the wheel. It was the top priority in 2013 and in 2014. And this defendant fancied himself the savior of this family. Equal parts black sheep and mama's boy, he would often try to help Wendy at Donna's bidding. When a problem was perceived regarding Wendy's love life, aka this breaking up with Dave situation, shouldn't break up with Dave, Dave's a great guy, Donna enlists the defendant to go in and fix it, to solve the problem. When Wendy didn't know what was best for her regarding a job opportunity, Donna sent the defendant to fix it. And the evidence has shown that Dan Markel was a major problem for Wendy, And that meant he was a major problem for Donna, who in turn made Dan Markel a major problem for this defendant. Enter Catherine Magbanua, who had connections to a criminal element, and she presented an opportunity to the defendant to do what he does and solve this problem. On Halloween 2013, the defendant began the process of soliciting Catherine Magbanua to commit murder. Magbanua solicited Garcia. Garcia brought in Rivera. So if the seed of this conspiracy was planted in the spring of 2013, when Donna was looking into converting the kids to Christianity or making this $1 million offer to Dan Markel, it took root that summer when the relocation was denied and the defendant began, quote, looking into all options to solve the problem of Danny Markel, including hiring a hitman. And the conspiracy grew further still when Dan Markel filed that motion to preclude Donna from having unsupervised contact with the grandkids, the grandma motion. And as Wendy Adelson relayed to Jeffrey Lacoste just 5 days before the murder, she was never going to be able to move to South Florida unless something happened to Danny. This conspiracy spread when the defendant met someone who could actually get this thing done. Someone who was in a position of trust in his life, a person who had connections to the kind of people who, for a price, were willing to point a gun at a complete stranger and pull the trigger. And guess what wasn't a problem once Dan Markel was dead? Relocation. Within a couple days, Wendy and the kids moved to South Florida. She changed the names of Professor Markel's children from Markel to Adelson. And just like that, their father was erased. No more squabbles over kosher diets or visitation schedules. No more death matches over marital assets. No more small town pit stop on the way to nowhere, Tallahassee. No more Dan Markel. And this case may have gone unsolved if not for a few things. Number one was Mr. Geiger. Does anyone other than James Geiger watch out for their neighbors anymore? He heard a loud noise and looked into it because something wasn't right. His observation and description of that Prius was critical to this investigation. It was really the only clue that police had from the crime scene, other than the fact that this appeared to be a targeted hit rather than a robbery attempt. How would law enforcement even start to find a single light-colored Prius? This investigation may have gone nowhere if not for the tireless efforts of law enforcement to cull through all those records you've seen in evidence or heard referenced in this case, including the tower dump, phone records, SunPass records, iClouds, surveillance videos, and so much more, looking for needles in haystacks. And they found a few. One is Garcia's phone number, which was in that tower dump from Premier Gym. And when cross-referenced with all the call detail records of all the Adelson family members, there was a single hit. A call from Garcia to Harvey Adelson on July 1st, 2014. An ill-fated attempt to confront who he thought was his baby mama's new boyfriend, but who turned out to be the father of his baby mama's new boyfriend. Then tracking Garcia's cell phone to match, time-wise, a particular SunPass that went through toll plazas at the same time as the phone. That SunPass was identified as being affixed to a particular rental car, Prius, which led to this rental contract bearing the phone numbers of both Luis Rivera and Sigfredo Garcia. Although you're not being asked to decide the guilt of anyone on the screen other than this defendant, it's necessary for you to understand the roles that each played in order to understand how it is that Charlie Adelson fits into this conspiracy. Whatever your thoughts about whether or how much these unindicted players are involved, today's not their trial, and you're not going to be asked to decide anything other than in reference to Charlie Adelson. What is alleged is that the defendant solicited Catherine Magbanawat to commit the murder. He conspired with Catherine Magbanawat to commit the murder with her, and that the murder was accomplished with the defendant guilty as a principal because he hired and paid for this heinous work to be done. All right, let's see what happens when we follow the Prius. So following the Prius, as we talked about, leads to the rental contract bearing the name of Luis Rivera and the phone numbers of both he and Garcia. Those two led to Catherine Magbanawat. Catherine Magbanawat led to this defendant. And I want to walk through exactly how we get from this light-colored Prius fleeing the scene to the defendant. Start with Luis Rivera. The defense may seek to discredit his testimony because he's a bad dude. His status as a felon and a gang member are definitely things you should consider when you're weighing his testimony in this case. But please consider that his resume as a bad guy was precisely why he was selected to do this gruesome job. Rivera's gang status made him a more attractive candidate to do this murder with Garcia. In the hot tub in March of 2014, the defendant mentions his connection to a Cuban criminal element. Jeffrey Lacoste reported this within a couple days of the murder when he couldn't have known the ethnicity of the killer. The evidence has shown that the connection the defendant had was through Catherine Magbanawat, and the criminal element was, of course, Garcia and Rivera. And we know that at the time defendant made that statement in the hot tub, the plan to kill Dan Markel was already well in the works. That statement was made just 3 months before the killer's first trip to Tallahassee in June of 2014. The statement reveals that the defendant wasn't scared of Catherine Magbanawat and her associates. To the contrary, he was boastful. He was bragging about it. He was the big man who was going to solve his little sister's problem, make his mom proud, and get away with it because he was thinking of everything. And he later would say and call JJ that nothing was done improper and suggest that no evidence could be available to tie the killers to him or his family. And he was confident enough of this to brag about it in that hot tub setting, which he thought could never come back to him. He was untouchable. Because if push ever really came to shove, who are you going to believe? An oral surgeon or a gang member? He's banking on that. In regards to Rivera's plea deal, the actual only condition of his plea deal is to tell the truth. And what did he tell us? Catherine Magbanawat hired Garcia, and Garcia hired him to do a murder. Why? To help the lady who he understood to be the dentist's sister to get her kids. Aside from fitting with the other evidence in the case, there were a few things that independently corroborated Rivera's testimony. One is that accidental discharge that he told us took place in the rented Prius. This was a fact we didn't know before and were able to confirm upon reinspection of the vehicle. He also told us about the location and timing of the money drop on the morning after the murder at his and Jessica's residence, which was able to be confirmed or corroborated initially by phone records and now also by Catherine Magbanawat's testimony. And of course, the phone records confirm Rivera did come to Tallahassee, not just on the July trip, which we knew about, but also on that first June scouting trip or attempted murder trip. The communication records tell us a few other things too. That's the June trip. July, June. This slide shows all the calls between our parties on the night before the shooters made that June trip to Tallahassee. You can see a 25-minute call from Catherine Magbanowa to the defendant at 9:17 p.m. on June 2nd, 2014. This call was placed while Catherine Magbanowa was consistent with traveling on her way back from Comfort Rental Car, where the first rental car was rented, to her residence. As soon as the defendant hangs up with Katie, he calls his parents' landline and has a 25-minute conversation. On the stand, the defendant was asked about the use of landlines and whether he believed them to be more secure. He testified that on the call he was being asked about at that time, that he was talking about switching over to a landline because he was in a place that had bad reception. If there's bad reception in South Florida at a dental office, what about all the other mentions of using a landline that we hear on the wire? Surely he wasn't in a place with bad reception for all those calls. And why call the parents on the landline? Surely they have reception in their South Beach high-rise. In the 2 years of phone records that were examined in this case, the defendant talks to his parents on the landline 28 times, or 0.07% of the times that he talks to them. So mostly on the cell phone by a large majority. 3 of these 28 times were on the days that the cars were rented to do these trips to Tallahassee. Whether or not that is a coincidence is entirely up to you. After the killers returned from Tallahassee on that first trip, we have a couple text messages of interest. On June 8th, 2014, the defendant indicates he's still working on Dad's birthday present, and Donna indicates, I know you'll come through. Then on July 6th, we've got Wendy Adelson with a location at or near her parents' place when she texts Dan Markell and confirms he's going to be in town for his own murder. This slide depicts the night before the second trip. We know Catherine Magbanowa and the defendant are together that evening at her place. He departs between 12:42 and 1 a.m. And then so after the defendant departs Catherine Magbanowa's residence, we've got Catherine Magbanowa calling Sigfredo Garcia. So within minutes of the defendant leaving, she calls Garcia. She talks to Garcia several more times into the wee hours of that night, the last one being at 1:56 a.m. And then at 9 a.m. the next morning, Garcia calls the rental car place. Once the Prius is rented, the second trip begins. The Prius is rented at 6:15 p.m. on July 15th, 2014. There are several calls between our parties on the day that the Prius is rented. So we just talked about the night before the Prius was rented. On the day the Prius was rented, we've got these 2 calls, several calls, including these 2 calls from the defendant to his parents' landline. Garcia and Rivera then depart for Tallahassee July 16th, about 2 p.m. and arrive in Tallahassee around 1 a.m. Although this trip was only about 36 hours from the time they left Miami to the time they returned, there were 12 phone events between the defendant and Catherine Magbanowa during that time, and there were 4 phone events between the defendant and Donna Adelson during that time frame, including late into the night on the night before the murder. On July 17th, Magbanowa relayed to the shooters that this murder had to be done that day because the victim was scheduled to leave town the next day. And we confirmed that Dan Markell was in fact scheduled to leave for New York City the next morning on July 19th. It's hard to imagine how Luis Rivera could have obtained this information, if not in that pattern that we consistently observe in this case. Defendant to Magbanowa, to Garcia, to Rivera, and back the other way. Certainly you're not really to believe that the killers divined this information from the professors flawed. That's not reasonable. Wendy offered that Danny sometimes put his travel information on Facebook, but you learned from Agent Sanford that there was no information about this particular trip on Danny's Facebook, so they didn't get it from there. This is because, as Rivera and Magbanua both told you, this information came in the form of that letter from defendant through Catherine Magbanua. How would these two hitmen even know where to go or who to kill if they hadn't been given any kind of instruction? Catherine Magbanua said she knew the plan was to kill Wendy's ex, but she never knew his full name until after he was killed. She did, however, deliver that envelope that the defendant put in her diaper bag to Sigfredo Garcia. The paper she knew contained the instructions for the murder. Defendant advised Catherine Magbanua that she should not touch the envelope or open it, as he had taken precaution to ensure that his prints and DNA would not be on it, that it would be untraceable to him, and she should do the same. She was to deliver the envelope to Garcia, and that's what she did. This is corroborated by Rivera, who says Garcia had a paper with him on the first trip, and it contained a picture of Dan Markel and a printed address. On the day of the murder, we have communications between our parties as listed here, with the red line representing the time of the murder. This flurry of calls between our persons of interest demonstrates the usual call pattern that we're seeing. Donna to the defendant, to Catherine Magbanua, to Garcia, and back. We have Wendy getting a text message on the day of the murder about her TV repair appointment from her mother, Donna Adelson. It indicates that Best Buy is on their way over to help you with the TV sets in your living room. Maybe she didn't remember which TV was broken. At 8:20, on the day of the murder, Wendy texts the defendant, "This is so sweet." That text was deleted. What does it mean? At 9:19 a.m., there's a phone call between Wendy Adelson and this defendant that lasts about 30 minutes? No. 18 minutes. So this is about 30 minutes before the murder when they hang up. They say they were discussing this TV that was not repairable. The TV that he gave her as a divorce present because it's cheaper than hiring a hitman. Only you guys can assess if you think that might just be a coincidence and nothing more. The Prius is at premiere at 9:16 a.m. The last phone communication between Garcia and Rivera is at 9:16. Afterwards, the phones turn off, consistent with what Rivera told you. We turned our phones off because we knew we were about to commit the murder, and they don't pop back up until I think about 12:30. The bus video catches them turning onto Benton Road to do the murder at 10:51 a.m., whereby they pull up right behind Professor Markel in his driveway. Sigfredo Garcia gets out of the Prius, approaches the driver's window, pointed his gun, and fired. Dan Markel raised his arm to protect himself, but it was no use. Professor Markel was executed at close range, whereby Garcia got back in the Prius and Rivera drove him away. Markel was left there to suffer and die. If not for James Geiger, there's no telling how many hours he might have suffered there alone and unaided. He fought for his life for 14 long hours before he finally succumbed to his injuries. The autopsy confirmed that he was shot twice at close range with a .38 caliber revolver, consistent with what Rivera said they brought as the murder weapon. Next, he was stripped, x-rayed, photographed, and dissected because he had become a piece of evidence. When Garcia and Rivera get back on the road, they're on a second bus video leaving town at 10:55. That narrows the time of this shooting down to a 4-minute window between 10:51 when they're seen turning on the Benton and 10:55 when they're caught fleeing the scene. And then we've got the 911 call from Mr. Geiger at 11:01 a.m. The first phone call that either Garcia or Rivera make after turning off their phones to do the murder. So first call after that is at 12:30, and it's Garcia to Catherine Magbanua. Magbanua assures them that they'll get their money the next day. This is the same time frame, roughly, that Wendy Adelson was visiting the crime scene. Wendy indicated that she went to turn onto Trescott from Centerville Road, observed a roadblock, and then turned around. But we learned that what she said happened could not have happened. Instead, the roadblock was all the way down here by the blue dot. I've got two blue dots. The one at the top left of the page there is where the roadblock was, that yellow line, 3 to 5 houses down from the scene. Trescott and Centerville is all the way down where the other yellow bar is. Visible from the roadblock that she approached and was observed doing so by Officer Brannon were multiple law enforcement vehicles, marked vehicles. There was crime scene tape up. There was a marked vehicle with an officer stationed at the perimeter. It was visible from that position that there was something going on at her kid's house, the house where they lived with their father. And what did Wendy Adelson do upon encountering this roadblock and observing that the police were present on the street where her kids lived? She turned around and proceeded to the liquor store to pick up her bullet bourbon. And the defendant says, well, this is another coincidence because she was asked to bring it to a party. Well, maybe. But the timing of the purchase and the fact that she went out of her way to go by the crime scene on her way to get the bullet bourbon should raise an eyebrow. But it's what she didn't do that's even more suspicious. She didn't ask Officer Brannon, hey, what's going on? She didn't call Danny. She didn't call the police to make any inquiries, or even the daycare to make sure her kids made it there that morning. Remember, Danny had her kids. She didn't even call the daycare. Meanwhile, our shooters are headed back to Miami. They pop up on an ATM camera at 6:45 p.m. in Pembroke Pines, Florida. And then both of their phones are consistent with being at Rivera's residence as of about 7 p.m. that night. At 8:23 p.m., Catherine Magbanua and the defendant make plans to meet up at his house. At 9 p.m., Donna texts the defendant, outside your house, to which he responds, 10 men. He told you from the witness stand that this text meant that Donna was just passing by his house on her way to Tallahassee and that they weren't meeting up. But Catherine Magbanua testified that when she arrived at defendant's house, the defendant advised her that his parents had just been there, and then he thought his mom had physically washed the money, which was damp when Catherine Magbanua received it. Magbanua finds the defendant to be carrying his gun around and in a frantic state. About the time that these two are meeting up at the defendant's house to do the money exchange, Dan Markell is pronounced dead at TMH. So he says he's going to be about 10 minutes out. Here he is, hitting at home at 9:40 p.m. At 9:46, we see Catherine Magbanua, consistent with being at Rivera's residence, and then consistent with heading toward the defendant's residence. She turns her phone off, and it stays off for 11 hours. When Magbanua's phone pops back up, it's 9:44 a.m. on Saturday morning, and she's headed back from the defendant's house or the direction of his house toward Rivera's residence. That's the money drop location. These phones are consistent with a meeting at 10:30 at Rivera's, which is the time, date, and place that he advised us he received his money from Magbanois. At 12:13 p.m., the defendant reaches out to Magbanois. Defendant, headed to the gym. Are you taking the kids to the beach? It's so nice. Magbanois, it's beautiful. Probably the pool. Defendant, nice, have fun. Ethan must be happy. This is what he's texting Magbanois within hours of her leaving with all the money in his safe. All of the money that he stared at and loved on since he was a child. And he wants to know if she's going to the pool. This might be a good time to remind you that the jury room is not a place to check your common sense. We want you to bring it in there. You have heard two wildly different versions of how this thing went down, and they can't both be right. I mean, somebody's trying to sell you a bill of goods. You were selected with the belief that you would be able to cut through the garbage and make sense of the evidence in this case and render a verdict that speaks the truth. A major problem for the defense theory is the idea that the defendant and Magbanois broke up after the murder, but then grew closer together over the next 2 years as she was collecting his monthly extortion payments. This is one of the more unreasonable parts of the defendant's testimony, well, it's definitely in the top 4, along with Latin King extortion payment plans, hitmen that hire themselves to kill someone that their intended future extortion victim hates. And most unreasonable of all is probably that Charlie Adelson, the guy that talks so tough in the hot tub about his unsavory connections, an arrogant man of extraordinary resources, a prize fighter of verbosity, would just lay down and take this in silence. Let's review some of these love texts. We got that one. Then we've got July 22nd. They're talking about the weather. They're talking about prescription shampoo. On October 6th, the defendant says, I love you. It makes me feel good that you care about me. I'm very lucky to have you as a part of my life. What? Lucky? Lucky. He says, I love you again on 2/24/15. According to him, he's now been making payments for 7 months. He's had her on the payroll for 6 months. No Latin Kings have contacted him in any way about collecting his outstanding debt of $195,000. Yet he continues to pay and love on Catherine Magbanois without reservation and without the slightest suspicion that she might be in on this, and without the slightest concern for helping solve the murder of who killed his brother-in-law. Defendant says he believed Catherine Magbanois wasn't taking any of the money even after he put her on the payroll. Checks are going to her because she seemed broke. Defendant's explanation for all the love texts with Catherine Magbanois is that he felt sorry for her. He felt she was in the same position that he was in, being manipulated in the same way that he was. But the fact remains, folks, that she's taking his money. She's connected to the guy that's extorting him. She's connected to the guy that killed his brother-in-law. It defies logic that he would then proceed to grow closer with her. But he has to say that because he can't, there's no other way around these texts. It also defies reason based on what we know of this man, that he would take her for her word and just empty his safe into her purse and then keep paying, presumably forever, without asking any questions, talking about it all, or reporting anything to the police. Magdanema began getting checks from Adelson Institute 2 months after Markel's murder, and she continued receiving checks from that time frame up until the bump. The checks stopped happening at the time of the bump, and you should be asking yourself what that means. Why did the checks stop happening? Well, you would reasonably figure they stopped happening because the parties got spooked, because law enforcement, they suspected the bump could be law enforcement. Law enforcement might be getting closer, take her off the payroll. If defendant was being extorted, as he told you on the witness stand, why would the payments stop? Why would the extortionist care if other extortionists had jumped on the bandwagon? Why would the bump impact the defendant's existing obligations to the original Latin Kings? The defendant said he put her on the payroll at Adelson Institute at her request to help her get insurance for her kids, with the understanding that the money was being funneled through her to someone else and she wasn't actually getting any of the proceeds. She was just going to use that paycheck to assist her with getting subsidized housing or insurance, I think it was, for her kids. But you can see from this slide, which is dated June 24th, 2014, that she's texting him about getting on the payroll prior to this alleged first extortion effort. He says no problem at that time. This is between the first and second trips. She's asking to be on the payroll. So the explanation from the defendant about why she's on the payroll does not fit with the other evidence in this case. So we've got all this evidence that points to the defendant. The motive points to him. When we follow the money, it leads to him. The Prius eventually leads back to him through these conspirators. And each time we have a big event in this case, we see these call flurries where all the parties are calling each other in that structure that I talked about. It goes from this one to this one to this one. But as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about the murder or if these call flurries around these key events are just a coincidence? A conspiracy can be shaped like a cluster with everybody talking to everybody. It can be shaped like a wheel with one central hub talking to all the different spokes. Or it can be shaped like a train car, which is what we have here, where one person talks to only the car in front of them and the car behind them. Law enforcement was asking these same questions. How is this conspiracy shaped? How does it work? How does information flow through it? What are different parties' relative roles within a conspiracy? And the wiretap and bump were designed to answer those questions. Did you notice that Donna Adelson, see how the paper's folded in half? She didn't even look at the paper before she put it in her purse. She didn't think this was a process server. She knew exactly what it was the moment this man approached. And then she just goes about her business. Does she give law enforcement this valuable information that could be used to solve the brutal murder of her son-in-law? I mean, this guy that approached her obviously knows something about who killed Dan Markel, right? So surely she went straight to the cops. Nope. Instead, she goes straight to this defendant, who goes straight to Catherine Magdanema, who goes straight to Sigfredo Garcia. In that first call after the bump, Donna says she doesn't want to talk on the phone, but defendant can't leave it alone. He asks, does it involve me or other people? Her answer, well, probably the both of us. Probably both of us. He says, what's that? Probably the two of us. So you probably have a general idea what I'm talking about. He doesn't say, no, I have no general idea what you're talking about. He says, all right. He absolutely does have a general idea what she's talking about. And if they were innocent, as the defendant has claimed, and this was in fact a second extortion attempt, there is not a reason in the world why they wouldn't just say that. I got approached by another one. One came and paid me a visit today. It's happening again. In call B, the defendant asked Donna to take a picture of the bump letter and send it to him, and she refuses. Why? Are the Latin Kings going to see the text? Do you think someone is trying to blackmail you? Maybe. Could be. I don't know. No. That's crazy. That's his response. And I'm not adding the emphasis on that syllable. He says it like that. That's crazy. How is it crazy? You're already being extorted by Latin King members. Remember, doctor? It's because he hadn't come up with that part yet. In call C, defendant calls back again to tell Donna not to talk about things in the apartment or any place. Why? Why? The Latin Kings aren't in there. And she doesn't ask why, because it's obvious. She says, oh, obviously. Why? Because they might be under surveillance? Well, who cares if they have nothing to hide? Here we see the first use of code on the wire. People don't talk in code if they've done nothing wrong. People do not talk in code if they haven't done anything wrong. Defendant knows, he knows that fact, and that's why he told you we didn't talk in code on the wire. We spoke carefully. What does that mean? Careful of what? Defendant also told you under oath that he regrets that his mom randomly used the word TV in this call as part of her careful talk. The defendant got Wendy Adelson a TV as a divorce present as a cheaper alternative to hiring a hitman. Dan Markell was killed by a hitman. Then the same TV is Wendy's alibi for the murder, a service appointment that her mother set up for her from South Florida. And then on the wire, Donna says, quote, "This TV is going to cost about $5." Does the defendant say, what TV? What are you talking about, since you inserted a random object into this careful talk conversation? No, he doesn't need to ask what TV, because he knows exactly what she's talking about, and he parrots it back. They asked you for $5,000? The defendant has advised you that this TV stuff is a coincidence. Is it a coincidence, or is it obvious they're referring to their conspiracy and this murder? Only you can decide which explanation is credible. The players in this case are smart. They've given a lot of thought to their preparations before this and to their explanations after. We know this seed was planted in early 2013, and it took over 1 year to come to fruition. And they really thought of almost everything. A clever TV-related alibi for Wendy, a frame job for Lacasse, and they insulated themselves by hiring Catherine McDaniel as a middleman, walling themselves off like those train cars, only communicating with the one in front and the one behind, and having no connection to the one further down the line. It's also important to note that in these first few calls, A, B, and C, that Donna Adelson describes the bump to the defendant, and she says the person that approached her mentioned an ex-girlfriend, but she does not say the name Katie or Catherine. Then, with only this very limited information, defendant calls only one of his many ex-girlfriends, Catherine McDaniel. In call D, defendant tells McDaniel that he thinks that this undercover, the would-be extortionist, said her name. We know this is true. The undercover did say Katie, but Donna had not yet told the defendant that. They only communicated in calls A, B, and C. And the only communication on those calls was that the person mentioned ex-girlfriend. On the wire, the defendant says he just called Katie, Catherine McVanoff, because she was his most recent ex-girlfriend. Well, we know that's not true because there's at least one woman that defendant will admit meets that definition between McVanoff and the bump, and that's Whitney Kick. On the stand, he told you all that all the you might not be the right Katie conversation. There's several mentions that, yo, I'm not sure you're the right Katie. I apologize. I'll feel stupid if you're not the right Katie. That was designed to reassure her that he was not setting her up. Once defendant meets with his mother and gets the details and the paper with the undercover's phone number, he meets up with Catherine McVanoff at Dolce Vita. If they had any evidence, we'd have already gone to the airport. Does that sound like an innocent man? Even if they bug your phone, you're still not talking about any of this. Talking about what? The cops would only bug your phone to get information about the murder. And if you don't have any, then there's nothing to not talk about. The cops aren't going to be doing a wiretap to investigate him getting extorted, which he hasn't even reported to law enforcement. So, not talk about what? Defendant discusses how he's going to start arming himself and is prepared to shoot. He told you under oath from the stand that he was being threatened and extorted by gang members for 2 years at the time that this recording was made. And now he's just starting to think about carrying a gun? Does this sound like a man that's been living in fear for 2 years? Does this sound like a guy who lays down and takes his lumps without question when threatened? Someone comes up to me asking for money in my house? He says that. Lines 23 and 24 on the top there. He says this as if it's a preposterous proposition that somebody would just walk into his house and demand money. But isn't that what happened to you? How is that preposterous? But wait, what changed? On the next page, he says, yeah, and guess what? When the fucking police show up and there's a doctor, there's an oral surgeon standing there with a dead gang member in his fucking driveway, they're not going to come down too hard on me. This is the same man who took the witness stand and swore under oath that he was a victim in this case and that he had been too paralyzed by fear of gang members to come forward and report his victimization. Dr. Adelson on this recording is the real Dr. Adelson. On the stand, he was so controlled, so knowledgeable about his case, so practiced. But there is no way to explain away his statements on this recording. When the bump happens, you get to observe this defendant in action in his role as fixer or problem solver. He's working those phones, trying to get Katie to investigate the bump and find out if it's legitimate or not, and also trying to reassure Donna that it's just the cops fishing and it's nothing to worry about. The bump is an actual recorded example of how this defendant acts when he is threatened by a purported extortionist. And how he acts is the complete opposite of how he's telling y'all he acted in the first extortion. Number one, he does not stay quiet about the bump. He talks about it a lot. There are multiple calls with Donna and Katie discussing the bump and what the next step should be. 2, he takes action. There are multiple in-person meetings with his mom and with Katie and eventually with his dad too about the bump and what to do about it. 3, he investigates the bump. He asks questions. He enlists Magbanua to find out who this is. He talks a lot about his concerns that this will not be just a one-time payment, but could turn into some ongoing problem. And 4, he doesn't take it lying down. He threatens Nazi shit if these people think they can threaten his family and get away with it. He suggests that the problem might require an additional murder. Quote, if he can't do it, I'll find someone else that can. Number 5, he's suspicious. He does not blindly accept the representations of this purported blackmailer that approached his mother. It's clear from the Dolce meeting that he doesn't fully trust Katie. He certainly doesn't trust this purported blackmailer that bumped into his mom. The person that represented themselves, the person that approached his mom represented himself as a Latin King gang member, right? I'm a brother of this guy that I met in Broward or whatever. And he's demanding money from her. Yet the defendant does not take his word for it that he's a gang member. He's not so in fear for his mother's life that he opens the safe and gets $5,000 more out and gives it to Katie. A pittance compared to the amount he's telling you he handed out to the first layer of extortion. Number 6, he doesn't pay. He doesn't bring the $5,000 to Dolce and give it to Katie and say, go pay it. Because that's what I do when I'm threatened, I pay. He doesn't pay, he doesn't ever pay. And it's only $5,000. Instead, he analyzes and thinks through and talks about every possible scenario. Defendant says it's one of 2 things or one of 2 scenarios. 1 being the cops, 2 being someone actually trying to blackmail his family about this murder. According to him now, he's been blackmailed for 2 years. And he's talking to Catherine Magbanua. He's talking to the person that's been collecting his money all those months. But at no point does he acknowledge the first extortion in the Dolce Vita meeting. Why not? Oh, because she asked me not to talk about it. Well, times have changed. There's a second extortion effort now, and they're approaching my mother. You think I'm not going to mention the first extortion? Your people have been running their mouths, and now they've tracked down my mother. You need to go get this under control. Nothing like that. Next in the Dolce recording, defendant begins to explain how to prove a crime. The police have to put the person at the scene, not just in the car. He's reassuring her that even if we, law enforcement, can tie her or the shooters to the Prius, that we'll never be able to charge them. Because they didn't come to Tallahassee, they didn't shoot anyone, they didn't do anything wrong, and therefore they can't be held accountable. But that is not the law as the judge has instructed you. Everyone who wanted this done and did some act toward accomplishing it is guilty as the one that pulled the trigger. He's also telling her that even if Rivera has run his mouth to this would-be extortionist, his word alone that, hey, if he goes to the cops and starts singing and says, hey, Rivera told me he did this murder, that's not going to be enough. Basically, he didn't use the word hearsay, but that's not going to be enough to proceed on an arrest in this case. This person knows information. So Katie, they'll be back. Whoever it is knows information. Information about what? You had nothing to do with it. Remember that, doctor? You've been extorted and that hasn't been reported. What information do they have? You mean information that could be used to solve the murder of your former brother-in-law? If so, why wouldn't you want those people to go to the cops? Why wouldn't you want them to come forward with that information? Then the guilty parties will be held accountable. Your extortionists will be jailed without you having to do or risk anything. Next, defendant talks about what will happen if the would-be extortionist, the undercover, is picked up by law enforcement. Next thing you know, this person is singing. Other people start singing. As soon as they have him, he starts calling your name out, and then there's going to be police at your door and at my door. If you're innocent of this murder, why are you worried about the extortions telling law enforcement whatever it is he knows about the murder of Dan Markell? Defendant says he wants to pay the money. Oh, got ahead of myself. He wants to pay the money, but he's explaining to her the problem with paying is that people might keep coming back or tell their friends who will jump on board as well. He's explaining to her the problems with paying a potential extortionist. What he doesn't say, which is what you would expect if he'd been getting extorted for 2 years, is Garcia, or whoever you've been giving my money to, has obviously been running their mouths, and now they are messing with my mother. Next, he gives instructions. Say my friends have no idea what you're talking about. And frankly, I don't know what you're talking about, but the name sounds familiar of who's incarcerated. So I'm going to give you something as charity to help the less fortunate. But do not contact these people again or they're going to the police. The whole time you're talking, just say, I don't know what's going on. Only use the words help and charity. This isn't the guy described in this first extortion who just rolled over when threatened. He's in control. He's giving the orders. He's giving instructions. Why would you have to give instructions to a blackmailer about how to handle a blackmailer? Next, the defendant says, now he's fucking with his wife and he's fucking with him, and you fuck with the king himself, you better kill him because he's going to be a big problem. And he knows who you are. If he can't do it, I'll have someone else do it. Defendant testified that this means the only way to stop Garcia is to kill him. He's not talking about killing him. He's just saying he's a really bad dude, and that's the only way to kill him. The evidence shows that he's saying if Garcia can't handle the undercover, he'll get somebody else to do it. Then he says, and so help me God, they fuck with my family, it's gonna be fucking Nazi shit because this will be done. I mean, Katie, I don't care what I spend, okay? I swear to God. Defendant and I went back and forth on the stand about what Nazi shit might include, and I think we ultimately agreed that that would be killing. And then he says, I don't care what I have to spend. If you're struggling to figure out who this man is, that's a good clue right there. He's going to buy a solution to this problem exactly how he paid for a solution to the problem of Danny Markell. Here he wants to know if Garcia has any bad feelings toward him, meaning, is Garcia willing to look into this and handle this for me? Or does he still hate me because I used to date you? If defendant had really been getting extorted all along, surely he'd say something like, I've been paying all this money, I've been compliant with everything. Can you get him to look into this and figure this out? Katie, I'll go to the moon and back for you. Why? Because she did something big for him, and he's going to be indebted to her for the rest of his life. Not because he feels sorry for her, not because she's his protector. He's the protector. He'll go to the moon and back for her because they're neck deep in this conspiracy together. Somebody messes with her, they mess with him. Somebody messes with him, they're messing with her. It's the same thing. Here he's demonstrating an understanding of, a rational understanding of how blackmail works. His example is that you could blackmail someone that's cheating on their wife, meaning you blackmail someone that you have dirt on. You don't go kill somebody and then go up to an innocent person and say, I killed your brother-in-law, give me money. At the end of the conversation, defendant says, you know who this is coming from? Inside. And then I don't have a slide for this, but he goes on to talk about what he will do for her. I don't have to sit here and tell you what I would do. I show you what I could do. You know what I'm saying? You know how I am. I look for things to do. You don't ask me for shit.
That's on the pool end there, trying to get the stream back up. Stand by for one moment. Tim, real quick, while we get the stream back up, what are your thoughts so far? Georgia seems to have brought all the passion and the receipts today.
Yeah, pretty powerful stuff. Started off with the motive. I like her seeds of the conspiracy, and the seeds took root in October. Took root in June, the summer. She showed the motive with the document, really showing how Donna was involved, how Donna and Charlie were doing all this for Wendy, and then it spews all the way forward how everything happened, how they had a motive, that you need to act, you need to lie, and then it goes into Charlie, this whole relationship with Meg Bonawa, and used his own words against him. Brought in a lot of the things I thought she should bring in. She did. She's doing great. She even tried to undercut the defense in the beginning of her opening, which is her closing. That was really good. Ceding that to the jury, what common sense. Don't lose your common sense. I thought was real powerful.
Tim, offer some pearls of wisdom. I'm just going to work to try to get this stream back up. It is on their end, but we're going to see this is the pool feed. But Tim, talk away. I'll be right back.
All right. Yeah, she seems to have made a lot of points. She had prepped. Obviously, she knew what she was going to do. She knew that the motive in any kind of murder case, you always want to know why. Why did this murder occur? And I think she took about the first 25 minutes showing the why, with the divorce, the motions, the grandma motion, and then they got into the how it was committed, which I thought was really good. I really liked her seeds of conspiracy. She threw in the law a little bit there, showing how you don't have to be the person pulling the trigger, and the law says you can be equally as guilty. She had a good flow to it. She even talked about Luis Rivera. I think it's a long closing. Sometimes you might lose the jury. You like to take a break. But I don't know if the judge was going to do that. I think she's been going like for an hour and a half, right? And sometimes you might lose a juror, miss points, but I like the use of the graphics. I thought that was good because it gets the attention of the jury. They're not just looking at her. Now they're looking at something to keep concentrating.
Yeah. Just a quick update. This is the pool feed that is out. It's buffering. It's happening everywhere. Space Coast is working and keeping an eye on it. They've had problems with the pool feed over the last couple of days. I don't know if how's the weather in Tallahassee, Tim Jansen?
It's perfect. It's beautiful today. Beautiful day.
It's
not the weather.
Sometimes the microwave trucks take hits. But this is a problem again with the pool feed. So we are efforting, as they say in TV. There we go. It's back up.
Here in Call J, we hear the reference to investment as code for the $5,000 extortion payment. A good investment would be someone who really does know something, not somebody that's just fishing, and will agree that $5,000 is going to handle. A law enforcement officer or somebody that's going to take $5,000 and just keep coming back for more and more and more and more, and it'll be a continuous problem. This is a composite side of all the places in the recordings that are in evidence. where the parties expressed concerns about the details that the undercover had. It's getting too detailed. He's coming up with a lot of fucking details, etc. It's obvious they're. Then you've got more property and listing code talk. More concern that the blackmailer might try to increase the amount. Here's a composite slide illustrating all the different calls where the defendant expresses concern that if he pays, that might not be the end of it. And the reason why I think this is so important is because you've been paying for 2 years. A guy that's living in mortal fear of Latin King gang members. He's pretty confident. He's pretty in control. Recall that in this one call, she basically says, I can't, she's really furious in this call. She's like, I can't do all this code anymore. I can't talk in code. Remember, defendant told you he didn't talk in code on the wire. That statement. This slide is a composite of all the places where defendant says if he had information about the murder, he would collect the reward money. First of all, whichever side of this case.
These are hits on the pool camera. I think maybe they're, getting more, needed more bandwidth. Maybe there's more interest than they expected, but that is not on our end.
It's hard to imagine he would collect reward money for information about the death of his own loved one.
Yeah. There's been a lot of comments about Rashbaum's behavior at the chair,
Yeah.
This is a little difficult because he's on TV. People can see him.
This slide is a composite of some of the occasions defendant mentions the option of going to the police. And these quotes are specifically in reference to him saying, if you're threatened, you go to the police. If you're threatened, you go to the police. And he has done that before, but he did not go to the police in this case. He didn't go to the police in 2014, not out of fear, as he would have you believe, but because he did this crime. He believed he had gotten away with this crime. He didn't go in 2015 because he was busy that year having the best year of his life. Financially, got in a serious relationship with a new girl, June Umchinda, cruised the intercoastal in his boat. This dude had solved the problem. Everyone was happy. Wendy and the boys were back in South Florida where they belonged. Mom was happy. He was making money hand over fist. June described the beginning of their relationship. June Umchinda described the beginning of her relationship with this defendant in October of 15 as a fairy tale. He is not sweating anything, folks. And that continued until the time of the bump in this case in April 2016, whereby the defendant became agitated, angry, and anxious. This was before the report concerning him was leaked. At the time of the bump, his behavior changed noticeably. June noticed it, and Ryan Fitzpatrick noticed it as well. He was erratic. Now, why on earth would he be more stressed out after his extortionists were arrested? He seemed perfectly fine to these witnesses when he would have you believe he was in fear for his life. And then he further told you that he was more nervous after the arrest because he feared he'd be falsely arrested. Why? You didn't do anything wrong. You're not going to get arrested. Now, yeah, after the report gets leaked, okay. But why are you so nervous before that? Or were you a hot mess because you knew that we were getting closer? Here's Catherine Magbanua and the defendant discussing if the undercover could be someone who's trying to be an informant. An informant for what, if not the death of Dan Markell? He's not going to be an informant on the defendant getting extorted, a crime he has not reported. Here they're talking about whether the undercover is getting his information from the inside or the outside. The inside meaning someone within the murder conspiracy, someone on that board, or the outside, somebody that one of those people told. Magbanua says it can only be one of two, apparently. If somebody's that desperate, not from the inside, because there's too much from the inside that the person knows from the outside, so they won't risk it. That's why I know for a fact it's not from the inside. And Adelson says it's somebody not from the first layer, but probably the second layer. Yeah, and they just made a big mistake, she says. As the wire goes on and the defendant proceeds to continue to analyze the additional bump efforts that law enforcement makes, that text message, the letter, the call to the Adelson Institute, he becomes increasingly confident that this would-be extortionist is an undercover agent. And then after listening to Donna's call to the undercover, he is completely sure of that. And you have never seen anybody so elated to be under investigation by the FBI for first-degree murder. Consider this in light of defendant's assertions that he was acting strangely after the bump because he was worried about being falsely arrested. To the contrary, he doesn't seem worried at all. He seems thrilled. I think he says it's fantastic in one of these calls. I want to turn briefly to your jury instructions. The defendant is charged with conspiracy to commit murder, solicitation to commit murder, and first-degree murder. Why all three? Because the defendant didn't just ask Catherine Magbanua to do this and promise her money. He didn't just set a plan of action in place toward doing it. It got done. It got done, and that's what makes it a murder. That's the difference between just conspiring. You didn't just conspire. It got done. This is the difference between just soliciting or just conspiring and being a principal to first-degree murder. To prove the crime of first-degree murder, I must prove to you that this was premeditated. Premeditation is defined as killing after consciously intending to do so. This murder, consciously deciding to do so. All right, so this murder was in the works for over a year. It began with the failed relocation efforts. When defendant first looked into hiring a hitman, it took root when he enlisted Catherine Magbanua, and she thereby brought in Garcia and Rivera to do the killing. The planning that went into the killing was extensive, spanning over a year, and it included the solicitation of Magbanua to find someone to do the murder, the preparation of that letter and that envelope that were placed in Catherine Magbanua's diaper bag, free of DNA or prints containing the directions for a murder that was delivered to the hired gun, Secretary Garcia. 3, the payments that were made in advance for renting the vehicles in the hotel room, the expenses associated with those trips. That was part of the planning. 4, the scouting and stalking of Professor Markel that we learned went on in both trips. And 5, the pressure that defendant applied to Catherine Magbanua after that first attempt failed. Get it done, get it done, get it done. 6, of course, is the payment itself. He paid for it. All the planning, all the meetings, all the precautions were coming to fruition when that hired gun fired those 2 shots that devastated so many lives on July 18, 2014. When you think about how this case was proven, we started at a single point, the crime scene, and we went in 2 totally different directions. We chased the Prius and we chased the motive, the bad blood with the in-laws. And the investigation could have stalled if either of these leads had resulted in a dead end. But all the little breadcrumbs led to the same place. The Prius led to Garcia and Rivera, which led to Magbanua. Bad blood and the divorce led to the Adelson family. The wire confirmed the defendant's specific involvement, not just some Adelson, that Adelson. Then Rivera and eventually Magbanua confirmed his involvement as well. I want to spend a moment talking about the principal instruction. We talked about this in jury selection. The defendant didn't pull the trigger, but that doesn't mean he isn't just as responsible as the person who did. Without every player in this conspiracy, the murder doesn't get done. In your jury instructions, it says there are 2 ways to prove defendant's guilt under the law of principles. If he intended that the murder be done and he did some act, preparing the paper, procuring Magbanua, or said some word, get it done, get it done, get it done, that caused or helped another to commit the crime, then he is guilty of first-degree murder. Or 2 ways you can find it. Or if he intended the murder to be done and he made or promised payment in exchange for the murder and the crime was committed by another person, he's guilty of first-degree murder. My burden today is to prove to you this case beyond a reasonable doubt. The jury instructions tell you that a reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. So when you're stuck back there deliberating, ask yourself, what is reasonable? When you're weighing a piece of evidence and deciding, like, is this a doubt or not? Is it reasonable? Does it fit with the other evidence in the case? If you find yourself saying, what if, or a fellow juror is saying, what if, without evidence to support whatever it is that comes after the what if, that's speculation. Remind your fellow jurors to get back on track. And that cannot be a reasonable doubt if it's speculation. My burden is to prove the elements of the listed offenses. Nothing more. If you have a question that I have failed to prove the answer to, but it's not one of these elements of the crime that the judge has given you, that is not a reasonable doubt. I'm concerned that you'll get back there and think, well, he didn't pull the trigger, so let's just do conspiracy and solicitation. You guys have worked too hard to render a compromised verdict at this point. I trust that each of you will follow the law and your oath to render a wise and legal verdict in this case. This defendant is guilty of first-degree murder under the principal theory, if ever anyone has been. So the efforts to distract you from this case and what it's really about, including these clear links in this conspiracy and all the evidence that establishes them, the text, the calls, the records, the testimony of Rivera, the testimony of Magbanua, all those things together. The wiretap, the phone calls, the iCloud messages, and the absence of any other reasonable explanation should all lead you to one conclusion. This is the puzzle. This is the puzzle. The image is clear. When I confronted Rivera with the defense theory that he and Garcia acted alone to kill Markel and then extorted money out of the dentist through Magbanua, he found it laughable. I wrote down his quote, that's a good one. It came out in this trial that in Garcia's trial, Rivera was portrayed as the sole killer, the bad guy. He conspired directly with Charlie Adelson, according to Garcia, to commit the murder through WhatsApp or some kind of way. Garcia's lawyers said this was all done without the knowledge and participation of Garcia.
Hi.
Then we learned in Magbanua's trial, Garcia supposedly conspired directly.
Objection, Your Honor.
Sure. I knew this was coming. I think he wrote some notes down. He was going to go to the sidebar after the closing about speculation. What if? I think he's going to ask for a mistrial. My guess.
Look at Charlie with his head in his hands. Look at him. Look at that expression. That says it all. But Tim, didn't you say it's a really bad precedent to object during a closing argument?
It is, unless something. He should have waited till she was done. I don't know what they're objecting to, but I know when she mentioned what if, and if that what if means something else, that's speculation. I think he's going to object to that because what if is his version of what happened. And I think he's going to say she gave improper recitation of the law. He may ask the judge for a curative instruction, and I don't know if the judge will do it. We'll see. But she was on the line. I mean, she was pushing it about what is speculation, what's reasonable doubt. It's never defined well enough, but they do the best they can, reasonable doubt, and jurors usually get it. And when lawyers try to explain it, the other side always objects.
On your memories of what took place during the testimony and evidence, you may continue with your argument.
Yeah.
Here we go again.
So he didn't give a real curative, but he gave an instruction. Listen to what the evidence was, not what the lawyers say. That's an easy
Now, here
fix.
we are.
Closings
in the trial
continue.
of Charlie Adelson, and the truth has been revealed. Once again, the state got this almost right. That's what you heard in the opening from Mr. Rashbaum. We understandably thought that his client, Mr. Adelson, was the hirer of this murder, but there's a twist. Nothing is as it appears to be. The defendant is really the second victim in all of this. Per his theory, the killers drove to Miami twice to kill someone they'd never met and had no motive to kill, in hopes that Charlie Adelson would, one, not report them for murder, and two, would instead agree to give them large amounts of cash at that time and on a payment plan over the next, years. Other than failing the smell test, there are a few specific problems with the defense theory. One, how would the killers have known where to go to kill Markel? How would they know who to kill?
I'm
How
glad
would the
she
killers
brought
have
that up.
known that Dan Markel was scheduled to leave town the day after the murder?
So
Three,
smart and important
possibly
right
the
here.
biggest problem, the theory itself makes no sense. Were they just hoping that this would work? We're going to go all the way up there and kill somebody, and maybe they'll give us some money. If they were going to confess to doing the murder to Charlie Adelson in order to try to get money, why not just put a gun to his head and take his money? Why not just rob and or extort him with the threat of death by Latin King? That would save you the trip and the murder rap. Their jigsaw puzzle theory is just a pile of pieces that don't fit together. Each explanation is carefully designed to explain one piece of evidence. But how many different explanations can you string together before it's no longer reasonable? How many coincidences can there be before it's no longer a coincidence? This defendant is not a victim. He's a criminal. He's wealthy, he's smart, and he's successful. But he's a wealthy, smart, successful murderer. My work is almost done here, and yours is just beginning. I trust that each of you will do your best to render a wise and legal verdict in this case. A verdict that speaks the truth. A just verdict. And that is a verdict of guilty as charged. Thank you.
Defense prepared to do its closing.
Yes, Your Honor. Maybe you just have a couple moments to set up.
Okay. You may set up.
I'm surprised the judge isn't giving the jury a break. They've been sitting for like 2 hours or so without a break, bathroom break. I'm surprised he didn't ask for 15
While they're
minutes.
setting up, the bailiff will escort you back into the jury room.
Oh, good.
There you go. There's the break coming right there.
Good for everyone.
Yes, and you just saw Pat Sanford walking out. People are commenting on Charlie's outward appearance as he seems to be getting whiter and whiter, as I think I would. There's Ruth Markel, knowing that Georgia was up there just nailing this. Tim Jansen, she basically closed out, coming full circle to how Rashbaum opened up opening statements by referring to this as a puzzle and puzzle pieces. Let's listen to Judge Everett. He's going to give final instructions here in just one moment. There's Phil Markel not sure who in the blue shirt, the shorter man looking back at us right now. And I'm
Judge
not
is
sure.
Judge is taking a break. He got the jury out.
Yeah. Okay. There's I don't know who that man in the orange is. I haven't seen him before, but he was just talking to Phil. Orange and blue glasses. There's Shelley Markel. It's possible that's her husband, although he hasn't been there.
As the witness coordinator.
Yeah, people are filing out. So Tim, basically Georgia brought it back talking about the puzzle.
She did.
She says this is the puzzle. The theory makes no sense. And this is what you said on our show last night. How did the killers know who to kill, where to go, why take 2 trips? I mean, those are some of the most basic points to make, but important, right?
Well, one, she had to get to the law because, during jury selection, a couple of people during jury selection didn't like the principal theory. Remember? A couple of them. And so she had to get that out of the way so that they can accept the principal theory and explain it that you don't have to be the one pointing the gun. And the law doesn't require that. She talked about reasonable doubt. And then she did. She went back and she attacked the defense's case even before they even brought it up in closing. How reasonable can it be if one thing's a coincidence, another thing? When does it get to the point where it's not reasonable? It's just contrived. And I think that's the point she's trying to make the jury do. She's reiterating that they took an oath, that they were going to base this verdict only on the evidence. And the most important thing, what did she do at the end? He's smart. He's successful. He's a murderer. She had to tell them that I believe I proved he's a murderer and I brought it to you. And if she didn't believe it, then she wants them to believe it. So she got it out of the bag. He's a murderer, no matter how clever, how smart he is. And that's important for a prosecutor to do.
Yeah, I thought it was very effective, by the way, to bring up those emails between Donna and Charlie again about the Nazi uniforms, the baptism. I mean, it just goes to show how dysfunctional and crazy this family is. I asked you at that point, was Georgia going too heavy on Donna? It sure seems like they're lining Donna up to be the next indicted co-conspirator in all this. Right now, she's an unindicted co-conspirator. And you told me Georgia was not going too heavy on Donna. Explain that.
Well, I don't think she is, because we go back to the why. Why did this murder have to occur? Charlie wouldn't have done it on his own. But he, at the insistence and the frustration of his mother and of Wendy, being protector of Wendy, it got to a crescendo effect that they needed to do something. And the mother pushed it, right? And the mother pushed it to this because Wendy would not stand up, do what she needed to do. This was as much about the kids going to see the grandparents as was Wendy leaving Tallahassee. So they, on their own, Charlie and Wendy, came up with this idea. And how do you know that? They're talking in code the whole time. They're always in code. You don't, like you said, people who are innocent don't talk in code. When you speak to your mother, you don't talk in code. People in a conspiracy talk in code. People are doing a drug deal, talk in code. Innocent people don't talk in code. They just don't. And it's so clear after the bump. They thought their lives were free. They thought it was done. They thought 2 years had passed. And lo and behold, now this person, she was cool and calm and collected when that bump guy dropped her that note. She was very cool. She didn't panic. She didn't run. She didn't go back home. She didn't call Charlie right there. She went and got the kids, and look how calm she was on that phone. And then that had 2 years to prepare. And I think Georgia laid out a strong case. Now we'll see what Rashbaum does. He sat at the table. He has to know every expression, every gesture, every smirk, every smile, every nod, everything. The jury sees it. We see it. People on the panel are commenting on it. It's not professional.
Yeah, there's actually, Tim, there's a comment right here from Julia. I don't know what Is Rashbaum acting appropriately as a defense attorney with his facial expressions and smirking, smiling, laughing, etc.? You mentioned to me about a poker face. He certainly did not have that.
It's hard to do. You hear something, especially if you think that she brings up some facts that were not in evidence. You want to stand up and object. The best thing to do is just write notes. And you saw him writing notes, and then you saw him like a pink highlighter. What that means is he's got his closing, but he needs to answer this question. This hit, this was a shot that was a take to against their case. He needs to respond to it. So he highlighted it, and you can see where she was making points because he's writing notes. His client was passing him notes. He's got to make sure, because he only gets one chance to speak. And if he doesn't answer those questions, he's forever, forever hold your peace. I thought she laid out a really good opening. I thought good use of graphics. She made a lot of good points. I thought she needed to. She needed to touch the law a little bit. Her rebuttal will be completely different than what this was. It will be a fist punch, not literally, but to their case. And she will have indignation. She will walk from the podium. She'll have hand gestures. She'll say how ludicrous this is. And it can be very strong in rebuttal.
Yeah, I was going to ask you because, I'm looking at my notes and it seems like she brought up almost everything. Not to put you on the spot, but I will. But if you had to guess right now, in terms of evidentiary items in this case, is there something that she's going to hammer home in the rebuttal here?
She kind of made all the points. Remember, she said probably the two of us. She mentioned the Nazi thing.
Yeah.
They don't know about us. They don't know the whole thing because they don't know my involvement. She brought up the fact that how these guys know how to get there, but she didn't bring up Wendy, right? She didn't bring up why would they not tell Wendy, and why would they let Wendy and the kids move to South Florida and put them in peril? Why would you do that? And she didn't bring up the funeral, right?
Yeah.
Because he can't respond. He didn't go to the funeral because he knew he was complicit in the murder, not because he was extorted, right?
Mm-hmm.
And they know that's an important point. The jury guy asked that question. I guarantee you, if they did a focus group, jurors are going to be concerned with that. That's why he asked that question.
And also, in regards, I think, to Sigfredo, and when speaking with Katie, he says, if he can't do it, I'll find someone else who can do it.
Right.
That's very damning, in my opinion. Also, Tim, what I thought was interesting, Georgia was highlighting how much this family hated Tallahassee. At one point, she said, stuck in this small place away from civilization. The jurors are not going to like that.
No, we kind of like our little small civilization up here with our change of seasons and less traffic and hills and trees, clean air. We kind of like it up here.
Donna was talking about brainwashing these children, even having a baptism, putting on Nazi uniforms. I mean, for a Jewish family to say that, I would have paid to see the looks on the faces of these jurors, but I was there all last week. They were pretty stone-faced, and I imagine that's how they are today. I just don't see a way around this. I don't think Daniel Rashbaum, with all due respect, has the resonance with this jury to bring it home, to sway them from what we just heard from Georgia. He too is a foreigner to them from Miami. He might as well be from Mars. Georgia also, I noticed, and I think I commented, was using y'all, which, if I'm saying that or Daniel Rashbaum saying it, it ain't going to fly. If Tim Jansen's saying it, obviously you're one of them up in Tallahassee. Kelly M here says, Tim, do you think there will be a verdict today?
Well, I feel better about her closing, which I thought. I know everybody was disappointed in the cross. I thought she did a really good job. And you're right. For the mother to bring up the Nazis and to a Jewish family, which can be like I mean, the worst thing that happened to Jewish people. For her to she reached that low
Okay.
to get transfer. How low else could she go? Commit a murder?
Everyone can be seated.
I
Judge is
see
back
Carl
in.
Stern back there.
Yep, Carl Steinbeck is here for the big moment in the gallery. He's been a best guest on our show. Let's listen in.
Good morning.
Judge Everett is stern, but he has a great sense of humor. He was talking to the jurors about baked goods in the jury room and how he wanted some red velvet cake last week, and he wasn't going to indulge unless it was something at least up to par with what he had hoped for. I think someone had mentioned cookies, and he said he wanted something a little better than that. So he's also a very affable, nice guy, and I think the jurors must like him as well. And he's got a great handle on the courtroom. This has moved along swiftly. Look at this. Ned Smith says, the judge loves red velvet cake. So do I. What's there not to love about red velvet cake? I love this judge. Tim Jansen, this keeps coming up over and over and over again. Does Donna have a lot more reason to be worried at this moment? Donna Adelson.
I think Donna does have. I think now that they put this evidence before the court, I think that the state now realizes they got a much better case against Donna than they thought. So I would think they might look into charging Donna.
I would not want to be Donna Adelson right now. Looks like the judge's mic is muted at the moment. Tim, how long a break do you think they'll take here before Rashbaum comes back? He's obviously setting up. He's not the most technologically savvy guy. Last week he was aggravating the judge a bit by not being prepared, technically speaking. So he's probably setting up his PowerPoint right now and getting ready to deliver his closings. KCL says, I'm going to have to get my boots back on to wade through all of Rashbaum's you-know-what.
I wonder if he's going to do the whole puzzle thing and the whole layers. I imagine he will.
I think he will. I just don't know how it's going to play. To me, Georgia was so thorough. I saw someone say that Georgia put her to sleep. I can't even understand that. I mean, she wasn't monotone. I thought she was almost playful at some points during this closing. It was totally different. I think she probably knows that people were expecting her to have a gotcha moment during the cross of Charlie. And I feel like she stepped up to the plate during these closings, coming out high energy, very deliberate, very specific in her talking points, and making all the necessary points. Tim, you know her a lot better than me. Do you think that she was aware of some of the criticism going into the weekend?
Oh, I think she was. I would have liked to have seen her taking a break after like an hour and 15 minutes and say, can we take a short break for a restroom break? That gets the jury their concentration back again. Now we got a sidebar, so this ought to be interesting. Wonder what we're at the sidebar. He might be making a comment about speculation. I think when she talked about speculation, that's not what the law is. I saw him write a note down, and he didn't go to the jury. I mean, to the judge, but I saw him. He was pretty frantic that he thinks she said something inappropriate. And if he doesn't bring it up now after the state's opening, then he's waived that on appeal. And you're really in two courts right now. You're in the trial court and the appellate court. If you don't preserve an objection, you waived it.
Can the judge, in some circumstance, look at Charlie? He is having a rough morning. That is for damn sure. Can the judge come out of this and say, disregard X, Y, and Z? It seems like that'd be awfully hard to do, Tim.
Well, what he might do, sometimes they do, is give a curative instruction. We'll see what he says here. Let's see if he says anything to the jury, or doesn't say anything at all.
All right, let's listen in.
I'm wondering if the court reporter is going back and showing the comment, and he's reading it on the computer to see if something he can pick it out. He's doing something.
It's like a replay in sports here,
and
so
he might be trying to figure out how he's going to word this to the jury and make sure he gets it right.
So, Tim, basically in real time, Judge Everett can go back and look at the closing argument that Georgia just gave, pick out a line, and make some kind of judgment on that.
If the court reporter has it, yeah. Or he could be writing something down. So we'll see.
How do these
a technology problem? But he's doing something right now, unless we're waiting on jurors to get back.
How do these court reporters? How does it work? Is it all voice activated? How do they capture everything in real time?
She's typing, and I think they're recording at the same time. It looks like she's doing something, but I can't tell.
And he's a court reporter, said she's got it.
I think Lise Fournier, who said that Georgia was basically no good today, might be Donna Adelson. What do you guys think? Lise Fournier says, "Shut up, nobody's going to charge Donna." Maybe Donna is Lise. You never know. And
I think that's right, Lise. We have no idea if they're going to charge Donna, but I can tell you the evidence I've seen in this courtroom, they certainly could.
Well said, Tim. T. Cancella says Charlie knows the next Latin king he is meeting is in person. Tim Jansen, that was a risky defense for someone who could get convicted. I would not want to be Charlie Adelson if convicted, because he's going to be in prison with some Latin King gang members, and he basically just threw them under the bus.
Yeah, they'd have to probably move him somewhere else. Depending on, we send inmates, Florida does, to different states for their own protection, especially law enforcement officers. They can be moved to Hawaii or California. You work a contract out, and they bring some here for their protection. But you know what? Invariably, the word spreads in the prison system.
Yeah, I have to tell you, I was looking at Charlie in person. He looked excited on Friday when he was up on the stand. Today, just look at him. Look at that.
No, he doesn't look good. Well, hell, who would look good? Knowing that the jury's deciding that you're going to prison for the rest of your life. And George gave a pretty good closing.
He looks like he stands not a chance, and I think he might be right. Catherine says, don't send him here, meaning out to California, even though Catherine's in Hawaii. So then there's this issue, Tim, that has come up before over here. We haven't talked about this in a while from Hotshot Guy. Rash may have suborned perjury when he came up with the bogus double reverse defense. That's a very fine line, isn't it? I mean, it would be tough to how would one even,
It is, and you don't want to second guess a lawyer's professionalism and ethics. because that is a fine line. He did meticulously ask him questions individually. I mean, they would have to say that he knew this was completely bogus from the start and helped him prevent. And that's a hard thing to do. And I don't want to make any comment on that because I think Daniel is doing the best he can. Look at the people he's dealing with, the family he's dealing with. Can you imagine how many phone calls he get a day? He probably gets from Donna about the trial every night about how it's going. Could you imagine?
I really, well, I kind of can, but then again, I sort of can't. Look at this. Adam Sack. I've watched trials and commentary for many years. Ideal setting here at SGS, which I found only within the last couple of weeks. Welcome to you, Adam. Not going to get any better attorney than Tim Jansen, who practices criminal defense in Tallahassee, knows all the players in the court. I'm just looking at Charlie, and I'm getting I'm getting contact anxiety, Tim Jansen, just by looking at him. My palms are sweating staring at him.
I wonder if a bunch of jurors had to use the restroom and there's only one restroom. And I mean, that was a long, I mean, we started at 8:45, but because of the jury instructions, we didn't start till 9. She probably started at 9:05. And it's really, what is it now? 11, almost quarter to 12.
Yeah.
A long time.
Yeah. If you have questions for Tim Jansen, get him in right now. I'll scoot to the bottom here and we will get him in for you. One question I just saw from Anna Montero. Does she still have time for rebuttal, Tim Jansen?
Of course.
There you go.
You will always get rebuttal. I don't know if he timed her, told her how much time. There's a law. I don't know what's happening here. This should not be happening. It's been much more than 15 minutes.
Please, everyone, do us one big favor, and it doesn't take a lot of energy. Hit that like button for us. It helps us tremendously. Thank you. Irish McGlass, super sticker here. Thank you, Joel, COE, Carm, Space Coast Mods, and especially Tim Jansen. Thank you all. I've had an amazing time doing this with Tim. It's not over yet, but we're getting to the meat and potatoes where the rubber meets the road.
You like that? I told you that the rubber meets the road.
The rubber meets the road. That's where we're at right now. Charlie looks on the verge of passing out. Charlie's acting for sympathy. Rashbaum is trying to figure out how PowerPoint works. This is super interesting. Ned Smith. Tim has been an excellent pinch hitter. People, of course, want you healthy, Tim, but they said it was sort of a weird stroke of not luck, but something that those ribs happen when they happen. So you're here with us. Charlie's been entitled his whole life, so this waiting has been torture for him. You know, it's funny to see tough guys when they're facing justice.
Like when the bully finally gets his due, right?
Yeah, in school.
The bully his whole life. Now someone stood up to him.
Tim, if you were coaching your defendant, your client right now, in terms of all these looks and the huffing and puffing, and what would you say to him? Would you say try to stay calm, try to look, stoic? What would you do?
I would tell them like I give them all. I give them all a piece of pad, and I said, if you can't not make a face, just write down. I don't care if you write it, just scribble. Just look like you're writing something down. Talk to the other lawyer. Just don't make faces. Don't make it look like it's bad. I've been in court where the most damaging evidence against my client, I look up in the air like it doesn't mean anything, thinking the jurors think if he's not paying attention, maybe I don't need to pay attention. And I try that sometimes too.
That is Charlie Adelson waiting for the jurors to file back in. By the way, if I can find it, that
everyone can be seated. Rashbaum, you may give the defense's closing.
Okay, here we go. Let's time mark this. 11:45.
Good morning. As we discussed in jury selection, Charles Adelson is presumed to be innocent. To overcome that presumption of innocence, the state has the heavy burden of proving beyond a reasonable doubt that Charlie committed the crime that they say he committed. We did not have to present any evidence whatsoever. That's how our system works. We did not need to prove his innocence. As you go through the trial, you were told that you needed to evaluate the evidence through a lens of innocence, a presumption of innocence. Now, I think we did prove his innocence in this trial, but that isn't the standard. That's not what you go back there and deliberate. What you see in this trial is a mountain of reasonable doubt that arises from the evidence itself, from the conflict in the evidence, and from the lack of evidence. The state's first question to Mr. Adelson when he was on the stand was something called Occam's razor. Their first question was referring to their belief that the simple answer is the preferred answer. You might recall them asking that question, the very first question they asked Ms. Charlie. Occam's razor, that proposition that the simple answer is the preferred answer, is the exact opposite of what our criminal justice system is about. See, Occam's razor is a guess. We don't guess in this country. We don't assume people to be guilty. We presume them to be innocent. And sometimes the simple answer is the wrong answer. Sometimes things aren't so simple. And that's what we have in this case. I talked to you in opening about puzzle pieces. I talked to you in opening about how puzzle pieces wouldn't fit. And that's exactly what you saw repeatedly in this case. Just one of those puzzle pieces is enough for reasonable doubt. But here we have a mountain of them. And let's talk about them briefly. Government Exhibit 59. This is their conspiracy chart. The first puzzle piece that doesn't fit is motive. See, Charlie Adelson didn't have a motive to upend his life. Charlie Adelson had a good life. His business was booming. He was supportive of his sister, but he didn't wake up in the morning thinking about Professor Markell. He didn't go to bed at night thinking about the problems his sister was having. He was living his life. Now, was it a bitter divorce? Absolutely. But through all of those crazy emails, are there any examples of any violence? None. Those emails, we spent about 10 minutes hearing about them this morning. Not Charlie's ideas. By the way, those emails weren't even done. You heard from Wendy Adelson. She never offered any of those things to Professor Markell. She never threatened him with any of those things. Crazy ideas? Yes. An upset mother? Yes. Pushing each other's buttons? Yes. But ladies and gentlemen, even the $1 million offer you heard, lawyers were consulted to make sure it was legal. a far cry from a murder. Their relocation motive. Relocation was denied a year before the murder. And by the way, Wendy Adelson and her two boys moving to South Florida would have no impact on Charlie Adelson. Would he be happy that they were there? Sure. Would it change his life? No. Now, you may wonder, why did we spend so much time on cross proving Wendy Adelson's innocence? The reason being is because on their exhibit, take a look who is in their conspiracy. They circled her for you in their opening cross. See, they were guessing about Wendy just like they're guessing about Charlie. What the evidence showed is that Wendy wanted to leave South Florida. But when it was denied in the summer of 2013, she made a life here in Tallahassee. What the evidence showed, and remember, I tried to get an email after email after email, and they fought me on it. Ask yourself why. Ask yourself what they were afraid for you to see. You saw that she made appointments after the time of the murder. She made them before. You saw she made plane tickets from Tallahassee to other places in the fall and winter. You saw that she got a new divorce lawyer. You saw that she was making play dates. And significantly, you saw that the entire family was making plans to come up here and see her celebrated for her book at FSU with incoming students. Why is that significant? Because their theory, their simple theory, is that she was part of a murder. It's a puzzle piece that does not fit. And we're going to talk about her trip down Trescott on the 18th, because that's a puzzle piece that they keep on trying to pound and doesn't fit, but we'll do that a little later. The next puzzle piece that doesn't fit. Who had the kids? See, one thing that the state and the defense can agree on is that the Adelsons love these two boys. But they would have you believe that they hired hitmen twice. And both times, who had custody of the kids? They would take a risk that these boys would be injured, killed. Does that make any sense? The June attempt. Remember, Wendy and Danny shared the kids 50-50. The June attempt, we learned from their witness, Luis Rivera, Danny had custody of the kids. And we learned that he wouldn't do the murder because the kids were there. The July attempt, they show you a text message about Professor Markell being in town. And they show you a text message where Wendy's asking for the boys on the 16th. The murder's done on the 18th. Who has custody of the kids? Professor Markell. It doesn't make sense. There is no chance if these people were behind the murder, they would take any risk that those boys would be in the crosshairs. Use your common sense. It's a puzzle piece that they cannot explain. And you know what else doesn't make sense? Is their alibi argument. So they make a big argument about this Best Buy repairman coming that morning, how it was set up for an alibi. The argument, by the way, makes absolutely no sense, because then they argue that Wendy purposefully went down the street of where she was supposed to get an alibi from. But let me ask you this question. Again, use your common sense. If the Adelsons and Charlie wanted to set up an alibi for not only Wendy, but themselves, why not do the murder on July 5th when each and every one of them is at a birthday party for their father in South Florida? Wouldn't that have been a better alibi? They didn't do that because they're not behind the murder. They didn't know it was going to happen. They have nothing to do with it. It's a puzzle piece that doesn't make sense. It's reasonable doubt. Sigfredo threatened Charlie. Now, the state has them as co-conspirators. The testimony is clear. Sigfredo Garcia hated Charlie Adelson. The testimony is clear from their own witnesses that Sigfredo Garcia wanted to kill Charlie Adelson. In fact, you hear that on March 11th, 2014, just 8.5 weeks before the first attempt, you hear that from Luis Rivera, that Sigfredo was stalking Charlie and he wanted to run him over with his car. He wanted to kill him. He's going to do that 8 weeks before he does a murder for him? Makes no sense. But it gets worse. You heard testimony in this courtroom from repeated witnesses, both law enforcement and otherwise, that on July 1st, just 17 days before the murder, Sigfredo Garcia tried to run Charlie off the road, threatened him, left a threatening voicemail that he was going to kill him, left it with his dad, but thought he was leaving it for Charlie. It's just 17 days before the state wants you to believe he went and did a hit for him. It doesn't make any sense. It's a puzzle piece that doesn't fit. Now, they'll come up here in rebuttal, and they'll probably say something like, Sigfredo didn't know what he was doing, Katie was siloing him of information. Ask yourselves if that makes any sense. Ask yourself if after the first attempt, he doesn't know exactly who he's killing. It's reasonable doubt, ladies and gentlemen. It's a puzzle piece that they cannot explain. The hitman joke. We learned in this trial that Charlie repeatedly made this off-color joke. And let me say something aside. You don't have to like Charlie Adelson. There are plenty of reasons not to like him. That doesn't make him a murderer. Now, this hitman joke, we learned that Charlie made it with people he hardly knew, that he made it repeatedly, we learned from their own witness that at a March 11th dinner, this is Jeff Lacoste, when he first met Charlie, Charlie made the joke. Ask yourselves, does it make any sense for a guy who is about to do a hit, about to murder someone, to go around town and advertise it? Doesn't fit. Reasonable doubt. Ask yourselves, does it make more sense for Catherine Magbanua, a professional liar and con artist, to hear the joke, to hear the $1 million offer, and start to get ideas? They want to call it coincidences. It's not a coincidence. Criminals do not advertise what they are about to do. That makes no sense. Reasonable doubt. Puzzle pieces that don't fit. Payment evidence. Miss Cappleman mocked in her cross of Charlie that this was a murder by layaway, meaning that doesn't make any sense. We agree with her. It doesn't make any sense. Murders for hire are not done by layaway. But you know what is done by layaway? Extortions. See, we learned in this trial that Catherine Magbanua got paid every month. She denied it. Their own witnesses proved it. We learned that she got paid $3,000 a month, $2,000 in cash and $1,000 in checks from the Adelson Institute. By the way, if Charlie's part of a murder, they're telling you how smart he is. Does it make any sense that he would create a paper trail of checks from his business to pay for the murder? It makes no sense. But aside from that, you heard from Special Agent Sanford. He has done around a dozen murder for hires. Never a payment over time. He's seen extortions like that, but never someone getting paid over time. The money drop was the next day. You heard about that. Ask yourself, if this was a murder for hire, why was payment not made before? See, the state gave you examples of days before the first attempt and days before the murder, where Charlie Adelson was with Catherine Magbanua. If it's a murder for hire, why didn't he pay her before? You heard on the night of the murder and the night of the extortion, she had to go run around town to find a babysitter for her kids. If it was planned, if Charlie was behind it, why would she not have it planned out that way? Why would he have not paid her before? See, because he had no idea it was going to happen. That's the only thing that makes sense. By the way, why would she need a babysitter at all if it was a murder for hire? If it's a murder for hire, how much time does it take to go pick up money? Go to the house, get the bag of money, and leave. See, the thing is, She didn't know how much time it was going to take. And you know why she didn't know how much time it was going to take? Because she didn't know how he was going to react. It wasn't just a pickup of the money on July 18th. It was a setup of an extortion. Now, we're going to get more into the extortion, but it's amazing to me that the state still doesn't understand what happened. And I wonder if they don't understand or they're trying to confuse you. So let me make this crystal clear now, and we'll get back to it later. On the night of the 18th, Charlie Adelson had no idea about anything about the Latin Kings. He had no knowledge of the Latin Kings. He doesn't find out anything about the Latin Kings until he's in the car with Catherine Magbanua moments before he goes into Dolce Vita. On the night of the 18th, what he's told is that Catherine Magbanua said she spoke too much and that a friend of hers had done this. Nothing about any Latin Kings. The payment structure makes no sense. The whole purpose of a murder for hire is to hire someone who you are not associated with, who you are not tied to. But yet, they would have you believe that Charlie would give them checks, would continue to text message with them, would continue to give them gifts because he was tied to a murder for hire. It shows just the opposite. It shows it's an extortion. Reasonable doubt. Katie's lies. Let me first start by apologizing if any of you were offended by the tone of my voice during my cross of Catherine Magbanua. See, the thing is, I think you all know me pretty well by now. I'm passionate. And I believe in the system. And the one thing I hate is when someone comes in this courtroom and lies. I hate even more when a murderer comes in this courtroom and lies. What we know is that the state called Catherine Magbanua. Talk about desperation in trying to prove their case beyond a reasonable doubt. They called a woman who lied under oath in her first trial. They called a woman who lied under oath in her second trial. They called a woman who tried to get Sigfredo Garcia to lie for her in her second trial. But worse, they called a woman who just a year ago lied during her proffers. She denied it. And by the way, they didn't question her on it. But you heard from their own witnesses, including Special Agent Sanford, that he walked out of the room. And he walked out of the room not the first 10 minutes. He walked out of the room over 3 hours after she started speaking. Because as he put it, what she was saying made no sense. And they're going to have you base this man's freedom on her words? And why did she lie? Because it's her only way out. But her lying didn't stop there. She lied to you. We caught her in lies. She said she didn't get paid overtime. We know she got paid overtime. She said she didn't know when the murder happened, when the plan changed to a murder, and that the plan was to murder Professor Markel. You've heard the liars. We see her lying to her co-conspirator, according to them, Charlie Adelson, on the wires themselves. We see her saying repeatedly to him that she has called the number hundreds of times, that it's a non-working number, that the number just rings, that they left a voicemail. All of those are lies. By the way, you know who she doesn't lie to? Sigfredo Garcia. You know who else she lied to? Luis Rivera. We heard that. She lied to him about the purpose of the trip. She lied to him about the lady being on the street. She told Luis that Wendy was on the street the day before the murder with her kids. Now, you may remember the judge read a stipulation in, which both sides agree on, that shows that Wendy could not be on the street with the kids. Luis Rivera didn't lie. She lied to him. She lied to him about the amount of money they got. She told him it was $100,000 when it was $138,000. And she never told him that she was getting paid every month. Remember, Rivera wanted to do a robbery. Ms. Cappleman comes up here in her closing, and she says, why didn't they just do a robbery? Wouldn't that have been easier? Remember, Rivera brought up that very point. And what is he told by Sigfredo Garcia? It can't be a robbery. Katie says we have to do it this way. Ask yourself why. The bottom line is, Charlie Adelson was conned. On the night of the 18th, he was scared. He didn't think she was part of it. He thought she was protecting him. That's why he thought the money didn't go up every month. That's why he thought he wasn't getting visited by any bad guys. And that made him closer to her over time. Reasonable doubt, a puzzle piece doesn't fit. Immunity. She was offered a get out of jail free card, and she didn't take it. She was offered it before her first trial. Now, she had an explanation for that. I didn't want to turn on my husband. But what about after he was convicted and his appeals were over? Remember, her first trial was in 19. Her second trial was in 2022. See, she couldn't take the immunity offer because when you take the immunity offer, you have to tell the truth. And if you're caught telling a lie, you not only lose immunity, but you've now confessed. You now have no defense. She knew she extorted Charlie. She knew she tricked him. She knew he wasn't part of the murder, and that's why she never took the immunity deal. Reasonable doubt, puzzle pieces that no matter how hard you try to hammer them in, don't fit. And let me ask you a question. Ask yourself why, when the state called her as a witness, they didn't ask her one question about the wires. Go back and look at your notes. Not one question about what was said and meant at Dolce Vita. Not one question of what they talked about in the car before Dolce Vita. And then Charlie Adelson takes the stand. And they have an opportunity to rebut him. They have an opportunity to call her back to the stand and say, you're not going to believe this crazy, unreasonable story that Charlie just wove. But they don't call her back to the stand. They don't ask her any of those questions because they don't trust her. Because they know that she can't answer those questions. Because the truth is, they have doubt. You heard it. They have doubt. That's why it took them 6 years after her arrest to even charge Charlie Adelson. Ask yourselves, why were they so afraid to ask her any of those questions? Security cameras. Now, let me be clear. In closing, Ms. Cappleman said that no one testified that Charlie's demeanor changed in 2014. No one was asked about that. He doesn't meet June and Chinda until 2015. But what we do know is his behavior did change. What we know from evidence in the record is that he started sleeping with a gun. What we know from evidence in the record is that he invested in camera equipment for his house and for the office. Now, the state comes up here and they say, well, there's this email or text message from months earlier where he's talking about putting in camera equipment. True. Guess what he didn't do months earlier? He didn't put in camera equipment. But guess what he does just weeks after he's extorted? Just weeks after Professor Markel is brutally murdered in broad daylight in his driveway. He puts in camera equipment. If he's a co-conspirator, who's he afraid of? According to them, he's the guy behind it. The camera equipment is to protect himself against himself? Reasonable doubt. The wires support what happened on the night of the 18th. They support that he was extorted. Now, I'll first talk about State's Exhibit 130. You'll remember this when I talk about it. It's 21 months after the murder and the extortion. It's before the bump. It's one of these calls about Dave. And it's very interesting and scary what happened in this trial on this call. State plays 18 minutes of the call, and then they cut it off. They ask the witness how important the call is because it's before the bump. Meaning there's no reason whatsoever that anyone is thinking that they're being listened to. 21 months after the murder, 21 months after the extortion. And at 20 minutes and 40 seconds in the call, 2 minutes after they cut it off, you hear what Charlie Adelson thought about Professor Markell. You hear him describe what happened to him as a tragedy. His own words, in real time. You hear him say to his mom that Professor Markell is not replaceable. They didn't want you to hear that. I want to go back briefly to the security cameras. Ms. Cappleman comes in here today and she talks about the times that Charlie went to the police. And she brings up examples of filing a lawsuit. She brings up an example of a dispute with a girlfriend. Those are very different than being told you have 48 hours to pay or you and your family are going to get killed. Especially taken in the context that just 9 hours earlier, Professor Markell was shot in broad daylight, executed. Reasonable doubt, a puzzle piece that just doesn't fit. Let's talk more about these wires. State's Exhibit 108, that's all the wires together. There's subparts of it. And I want to draw your attention to A, B, and C. These are the first 3 calls with Donna Adelson after the bump. What you see on these calls is that initially, for at least the first call and a half, Charlie Adelson has no idea whatsoever what she's talking about. None. Now ask yourself, if you did a murder with someone, wouldn't that be the first thing on your mind? He has no clue what she is saying. He's talking about Yelp. He's talking about the IRS. He's talking about being sued. He has no clue. She says, it's about the 2 of us. We've already done this. We beat a horse to death on this. It's about the 2 of us. You were extorted, and now I'm being extorted. It doesn't even make sense under their theory of murder. By the way, on those first calls, she wants to meet with them when Wendy and Harvey are not around. I'm confused. I thought they're co-conspirators, according to the state. A puzzle piece that makes no sense. By the way, he starts to figure out what it is when she brings up blackmail. And when she brings up, and you can listen to it, you'll see the hesitation in his voice that he needs to bring cash when they meet the next day for lunch. He starts to figure it out. And what does he immediately shift his attention to? Don't take my word for it. You can listen to the wires. Was the guy white or Hispanic? Was the guy wearing a disguise? Was the guy threatening? Did he give you 48 hours? he's trying to figure out if it's the same people. Now, they talk about why would he call Katie? His mom doesn't say anything about Katie, and he has other ex-girlfriends. Well, he has only one ex-girlfriend that on July 18th came to him and said, you have to pay money. I'm not part of this. Because if you don't pay money, they're going to kill you. And see, they ignore D 1392, part of the same exhibit. He slips. 3 minutes and 34 seconds into this recording, Charlie slips. See, he's got to be careful on these calls when he's talking to Katie, because he doesn't want her to think that he's setting her up and setting up her friend, whoever that might be. He doesn't know at this point. He has a guess, but he doesn't know. And the reason why he has to do that is because he needs her help. She's the one who is most equipped to help him figure out, is this a bad guy? Because if it's a bad guy, he's worried they're going to get killed. She says his first instinct isn't to pay. We're going to get to that. His absolute first instinct in Dolce Vita is to pay. You can listen to it. So he has to be careful in how he talks to her, but 3 minutes and 34 seconds into D 1392, he says the following. I mean, you didn't do anything with my mom. And she responds, what would I do with your mom? And he says, just checking. What could that possibly mean if he's not referring to the extortion? How could that possibly be talking about a murder for hire? It cannot be. 3 minutes and 34 seconds in, give or take. D 1392. Don't take my word for it. Listen to it. On the wires, Charlie Adelson's way of calming down his mom, and what he is hoping for is that it is the police. How does that make any sense if he did a murder? He did a murder, but he's hoping that the police are onto him? It makes no sense. See, he's hoping it's the police because he didn't do a murder. And if it's the police, no one's going to get killed. They went through Dolce Vita with you, and I'll probably go through it a little bit more with you later. But let me say this. Listen to it for yourselves. Think about the parts that they left out in their closing. How about the 9 times that he says something to the effect of, we have nothing to hide. We didn't do anything. How about the 36 times he says that on the wires? How about when he says in Dolce Vita, these people only know part of the story, or they think they know part of the story? What could he possibly be talking about if he did a murder for hire? What he's saying is, they think we did a murder for hire. They don't understand I was extorted. They think they know the whole story, but they only know part of the story. And that's why I hope it's the police. In Matsuri, he says twice, the funny thing is. Listen to it in the context. What's funny is they don't realize that the sting they put together is close to the truth. PP 2325, 7 minutes in. They opened on it, but they didn't want to play it for you. They skipped over it. It's in evidence. You can hear it. There's talk about it being someone not from the first layer, but probably the second layer. Talking about extortion. The first layer is when he was extorted on the evening of July 18th and his payments for the 21 months. The second layer is the bump. He's trying to figure out, is it the police? Is it a copycat? Or is it the same guys? On the wires, who are the only people that call and speak with the undercover? They call from their cell phones. They don't make a big deal about star 67. They call from their cell phones. They don't get burner phones. The only two people that speak with the undercover, Charlie Adelson, Donna Adelson. Ask yourself why. Reasonable doubt, a puzzle piece doesn't fit. Look at the text messages. Now, I fought to get in these text messages. Ask yourself why I had to fight so hard.
Which I'm going to object to Connor's rulings and
Sustained.
legal objections.
Please move on.
Look at the text messages that are in evidence. Nothing out of the ordinary. Everything explained. He didn't hide or flee. Not like Catherine McBanoa. Another lie she told you all. She said she didn't know it was the police outside. She didn't hide. You heard she hid. You heard she got a burner phone. II 1393, 1 minute and 47 seconds in. A call between Catherine McBanoa and Sigfredo Garcia. 1 minute and 47 seconds in, Katie tells Sigfredo that she's worried, in essence, that Charlie's parents, Donna and Harvey, are going to go to the police. If they're co-conspirators in a murder for hire, why would she be worried that they're going to go to the police? It doesn't make any sense. Simply put, these puzzle pieces and others do not fit the state's theory. Why? Because while they want to make this a simple explanation, while they use words in closing 13 times could, 6 times maybe, 2 times maybe not, 3 times suspicious, 6 times coincidence, that is not beyond a reasonable doubt. That is not what we do in this courtroom. We presume innocence. We don't guess. We don't ignore things that don't fit into the theory. Now, I want to turn to the testimony at trial, and I will try not to be repetitive. The first group of witnesses, we asked very few questions. We don't disagree that the murder of Professor Markell was horrific. They showed you those pictures today. I can't look at them. These people that killed him were animals. He agreed that the police work was phenomenal. That's why they caught the 3 people who did this. You also remember, check your notes, that none of those original witnesses said a word about Charlie Adelson. Now, the first witness of substance was Agent Sanford. He came twice, so we're going to deal with him each time. The first time he came on the stand, let me say this. He's an honest and truthful guy. He's exactly what you want from a witness. Compare him to Catherine McBanwell. Compare him to Ryan Fitzpatrick. We'll get to that. They put in emails through him. And they showed that there was distress in the family, that there was anger over the relocation issue and divorce. They also showed that the relocation issue was denied in 2013, the summer of 2013, a year before the murder. We saw that there were very few emails from Charlie Adelson, although he was aware of some of the crazy emails. And he would say things like, good idea. We learned about the $1 million offer and how Charlie was going to pay 1/3 of the $1 million with the hopes of getting paid back. And we learned through Agent Sanford that there were emails that showed that this $1 million offer, the Adelsons consulted a lawyer on it to make sure they were doing things legal. We learned that in his experience, murders for hire aren't paid this way. We've already talked about that. And we learned that there is ongoing discussions about where the kids were going to go to school in the fall of 2014. Ask yourselves, why do you need those discussions if you know you're about to kill a guy and relocate? And then we heard from Wendy Adelson. And again, we spent a lot of time crossing Wendy Adelson because we wanted to show you that their theory on her was absolutely wrong. And one of the things I didn't mention earlier, in addition to the plane tickets and the hiring of a divorce lawyer and the scheduled meetings and the custody arrangements in August, you see in Defense Exhibit 6 that she's trying to buy a house. Now, they talk about a house on Halloween Halloween of 2013 that Charlie convinced her not to get. What about when she's looking for a house just a month or so before the murder? No evidence that anyone's trying to stop her then. She testified that she was not worried about disbarment. By the way, we called her lawyer to the stand to buttress her testimony because the same motion was made against her. And she testified she wasn't worried about disbarment either. She testified that she never made the $1 million offer or the Christianity email threats. We showed through emails and they're on the wires to support her testimony that after the murder, she was scared and sick. You don't have to take Charlie's word for it, and you don't have to take my word for it. It's on the wires. On the wires themselves, it talks about how Wendy is finally getting over this. We showed through stipulation that there's no way she and the kids could have been on the road the day of the 17th. And we showed that through her that Professor Markel posted in a lot of places about his travel. Now, we have no idea how Catherine McBanwell and Sigfredo Garcia knew where Danny lived and knew when he was going to be out of town. We don't know because it has nothing to do with us. But we showed you possibilities of where the information could have been found. That, ladies and gentlemen, is the definition of reasonable doubt. As opposed to some crazy explanation, and we'll get to it, that just 3 weeks after dating, he put some letter in her bag that she doesn't know what the letter is about and what it says, but it must have been that. Does that make any sense? And we showed that on the day of the murder, Wendy Adelson voluntarily was interviewed for hours without a lawyer. She gave her phone. She let them search her car. She let them search her computer. And she named everyone who could have done this. Everyone that came to mind, the first person she named was herself. And yes, she mentioned the hitman joke. And then she said, but he wouldn't do it. By the way, talk about a puzzle piece that doesn't fit. His co-conspirator goes to an interview with law enforcement on the day of the murder and tells law enforcement about the hitman joke. Does that make any sense? It does if they're not co-conspirators. It does if they had nothing to do with the murder. Reasonable doubt. She talked about her problems in the relationship with Jeff Lacoste, how he was stalking her and jealous. She was adamant that Charlie never actually looked into hiring a hitman, that was a lie. And was adamant that the dinner they had weeks later, no one called it a celebration dinner. Her testimony, a state witness, did just the opposite of proving their case. It gave more reasonable doubt, and I would submit proved innocence. The next witness was Officer Brandon. His testimony was short, but indicative of the state's case. He testified that Wendy drove down Trescott. Again, she explained why. But more importantly, the state tried repeatedly to pound this evidence in to show that Catherine Magbanawa made a phone call, got a phone call at 12:30 and said, I know it's already been done. Remember that testimony? And the state was desperate to say that that phone call somehow came from Wendy Adelson. But look at their own exhibit. The phone call is at 12:30. They showed it to you today. Look where Wendy Adelson is at 12:30. She's nowhere near the residence. According to the state's theory, she must have mind-reading ability. But yet they continue to try to pound that puzzle piece into place. They double down on it. Ask yourself why. Jeffrey Lacoste. The jury instructions will tell you to evaluate bias in witnesses in determining their truthfulness. It is not up for dispute that Mr. Lacoste was a jilted lover who was stalking Wendy Adelson. You heard that from Hale, Officer Hale, the later witness. More importantly, though, Jeffrey Lacoste thought that the Adelsons and Wendy had tried to frame him. He was upset about that. They thought he tried to frame them. He thought they tried to frame him for this murder. And so his testimony was shaped by that anger. The truth is, he had a nice time at dinner with Charlie on March 11th at Yardbirds. There's a text message in real time, unsolicited, confirming that. Charlie didn't send him a text, he sent Charlie a text. The truth is, when he talks about Charlie having associations with the Cuban element, whatever he testified to, by the way, no one in this case is Cuban. Tell you a secret, Sigfredo Garcia is not Cuban. Luis Rivera is not Cuban. Made up. He admitted that even though he supposedly thought Wendy was part of a murder, he would have gotten back together with her. Does that make any sense? He says that Wendy told him that Charlie really looked into hiring a hitman. He says she told him this when they were breaking up. Does that make any sense? He says that after they broke up, she told him it was a celebration dinner. Meaning she's telling him, I did a murder with Charlie. Does that make any sense? And then you hear about these notes. You hear it from Officer Hale and others, how there's a bunch of notes. He took a bunch of notes. I never saw the notes. You know why? He destroyed them. Ask yourself why. His testimony makes no sense, is biased, and should be discounted as nonsense. As someone who is angry because he thinks they tried to frame him. Stephen Webster. Honest. Nice. This was Professor Markel's divorce lawyer. But notice something. He's not a divorce lawyer. He's a criminal lawyer. Never litigated anything in the case. But yet they call him to try to bolster some sort of motive that Wendy Adelson was so fearful and the family was so fearful that she was going to be disbarred, that these motions were going to be successful. When I asked him, did you know that the judge was frustrated with Professor Markel? He had no idea because he wasn't the lawyer at the time. Junam Chindo. She testified that Charlie sleeps with a gun. Why would he sleep with a gun if he was part of the murder? She testified that during the bump, she wasn't actually clear, but I'll give him this. During the bump and after that, he was upset. He was acting weird. Of course he was. He didn't know whether his family was about to get killed. He didn't know who was extorting them the second time. She also testified how Charlie flew out of the country and always returned. Ryan Fitzpatrick. To me, this witness sums up the state's case. And it's scary. He had no firsthand knowledge of anything. And you learn only through cross-examination that years after the murder, when he was about to be sued by Charlie, he threatened him to go to the FBI and say things bad about it. You learn that just days before coming in this courtroom, He's on a blog taking bets about whether he can cause him to serve the rest of his life in prison. Disgusting. Luis Rivera. The state still doesn't get it. I'm not going to discredit his testimony, just the opposite. To me, Luis Rivera's testimony was in some ways the most significant. He's an animal, but he was truthful. He said what he knew. It proved firsthand why you must find Charlie Adelson not guilty of all 3 counts. It proved firsthand reasonable doubt. It was an aha moment. Let me remind you of it. He admitted that Katie was the mastermind of the killing. He said that everything had to be cleared through Katie. He said that everything he and Sigfredo knew came through Katie. He said he wanted to do a robbery, but Katie said he couldn't do a robbery, that it had to be done this way. We went through all the lies that Katie told him through Sigfredo, the lady being on Trescott, the purpose of the trips, the amount of money. He now understood why he got $37,000 instead of $35,000. We went through the fact that he knew nothing about the payments over time or the gifts to Katie. And here was the punchline. When asked, could this have been an extortion and not a murder for hire? Could they have lied about that to you too? His answer was yes. One of the 2 shooters admitted to you that knowing what he knows now, this could have been an extortion. That, ladies and gentlemen, is the definition of reasonable doubt. Am I going to discredit him? No. I'd never talked to him before. The first time I met him was in this courtroom. Their witness says it could have been an extortion. Catherine McVanawa. Now, we've talked a lot about her already, and I don't want to talk about her much more. But ask yourself about all her lies. This Halloween nonsense. Go take a look at Defense Exhibit 34. Charlie Adelson knew nothing about Sigfredo Garcia on Halloween. You see it in text message on November 27th. They'll try to spin the text message. Read it for yourselves. Defense Exhibit 34. Her testimony alone should give you a mountain of reasonable doubt. Clarissa Libierdo and Erica Johnston. The state called them to prove something we already admitted in opening. Katie didn't work at the Adelson Institute. Mary Hall, truthful witness. She confirmed that Katie got paid overtime. She couldn't give you exact numbers, but when you look at the numbers, you see it corresponds to around $3,000 a month. She confirmed that the Adelson checks created a paper trail, something that Charlie had no issue with because he was not part of a murder. She confirmed the gifts, the payments for the car repairs. By the way, she confirmed that he put many of those on his credit card, creating a paper trail as well. Now let's talk about those gifts, because I want to make sure everyone understands it. Over time, Charlie became more and more convinced that Katie was not part of the extortion. But he needed her help. See, because as long as she was helping him, he knew he wasn't going to be paid a visit. As long as she was helping him, he knew the money wouldn't go up. And so he tried to keep her happy. Now, they want you to believe he tried to keep her happy because he was worried that she would go to the police and report a murder that they both did together. Does that make any sense? No, he tried to keep her happy because he wanted her to know he was appreciative that she was helping him. Investigator Corbett, a thorough witness, straightforward guy, honest. This is the phone analyst investigator. He looks at patterns. He doesn't know what's said on the phone. It's guesswork. He sees the frequency in the amount of calls. And he looks for patterns. Now, when asked, could these calls be because it's a boyfriend and a girlfriend, a mother and a son, husband and a wife? He says, of course. He also confirmed that there's an absence in records. That by the time they arrest Charlie Adelson in 2022, we can no longer get phone records before when they got him originally. We can no longer get SunPass records. SunPass records would show that Donna Adelson and Charlie Adelson, Donna Adelson and Harvey Adelson never were at Charlie Adelson's house that night. He confirms that. And he also confirmed that there were a lot of calls that are consistent with when Charlie is driving to work and coming home from work. Now, I want to talk about this landline issue because it is crazy. It may be the craziest thing in this case. And it's done to incite you. When you think about it, you're going to see it means absolutely nothing. So they have a chart. She showed it in closing of frequency in using the landline, calling the landline. And you see that Charlie hardly ever calls his parents' landline. Okay? And they want to show you that on a particular day or days, he calls the landline. So that must mean something. What does it mean? He's using his cell phone. He's calling his parents' number that has been the same number since the year he was born. Grasping at straws. That's what that is. Then they confuse a wired call with those calls. What they're confusing is there's a call after Charlie. You'll see it in, go look at it. There's a call after Charlie learns about the text message that they sent to his mom at like 2 a.m. You'll recall that he and his parents meet at the pool at their apartment. And you'll recall that Charlie then goes and he goes to a friend's office and he gets a call or calls Katie. And then he says, I'll call you from a landline. And that's because he doesn't get good service in that office. It has nothing to do with his parents' apartment. This landline, it doesn't mean anything. It's like magic. It's like they're putting on a magic show. Use your common sense. Corbett also confirmed that Charlie's house was a stone's throw away from the turnpike, and that the most direct route to Tallahassee for Donna and Harvey was to take the turnpike, which passes right outside his house. And he confirmed that Charlie didn't leave his house for more than 24 hours after the night he was extorted. They show you that gym text. Corbett, their own witness, confirms he didn't leave the house. We're almost there. Special Agent Jimenez. No real substance. He pretends to be a Latin King gang member. This is important. When he does the bump of Donna Adelson. It's going to be critical that you hear that and understand that. He pretends to be a brother of Tato. And he testified up here that the reason why he did that is because he wanted the Adelsons to know that it was gang related. Up until this point in time, we're now in 2016, April 19th. There's nothing about Latin Kings. No matter how many times Ms. Cappleman wants to ask Charlie about Latin Kings in 2014 or talk to you about Latin Kings in 2014, they're nowhere near this case in Charlie's mind until 2016. And more precisely, until April 20th of 2016. And we'll get there in a moment. But Jimenez testifies that he inserts this into the bump. Then we heard from Agent Bronstein and Keith McElvey. And we learned from them that only part of Dolce Vita is recorded. You saw it's difficult to hear. You can't hear almost anything Catherine McBandle was saying. And we learned that there's numerous recordings. By the way, you have two of the recordings. I submit to you that the recordings are the exact same. You can listen to them for yourselves. But it's interesting where they started the recording that they played for you. And we know what he meant when he said that because he never fled. You heard from Special Agent Sanford. He went to places far away. Extradition's tough. And he always came back. Investigator Kendall Matsuri. Probably my favorite question in the case that you didn't understand until later when I asked him whether he didn't like sushi. That's how they knew he was police. But he testified that when he arrested Charlie in 2022, there was barbed wire and cameras all over his house. Ask yourself why. He confirmed that arrest was 6 years after the arrest of Sigfredo and Kate. Ask yourself why. Now they put on evidence through Special Agent Sanford a second time. And they were called, they called him to put in all the wires. But he couldn't really talk about what the wires meant because he wasn't part of those conversations. Only two people could really talk about what they were meant. And frankly, I thought maybe we'd have a he said, she said case in this case. They didn't call Catherine McBandle. You only have one version, the truth of what was said on those wires. And we'll get to that. Sanford the second time confirmed that Katie was hiding when the police came knocking on her door. She lied to you about that. He confirmed that Katie lied during her proffers, that he had to walk out She lied to you about that. He confirmed that there was no evidence of any calls between Katie and Charlie after Sigfredo's arrest in the spring of 2016. He testified to the numerous lies that Katie told on the wires to Charlie and how she didn't lie to her co-conspirator, Sigfredo. That was their case in chief. We had no obligation to put on a case. When you're evaluating the presumption of innocence and whether they met their burden beyond a reasonable doubt, stop right there. They didn't come close. But we put on a case. We talked a little bit about lawyer Adelson. We can move on from her. I think you get the point of what her purpose was. But Charlie Adelson testified. And when he testified, you saw him explain on direct what happened on the 18th. How he was extorted. How he was fearful for himself and his family. You heard why he didn't go to the police. Now, listen, some of us might go to the police, some of us might not. You heard why he didn't go to the police. Reasonable. He had just seen what had happened to Professor Markel. He knew the danger of these people. And she wants you to think that he would negotiate with Katie that night. He was stunned. What was there to negotiate? And again, there's no counter narrative because they didn't call Katie Magbanua and ask her about it. You heard why he thought Katie wasn't part of it and was protecting him. And you may remember Miss Cappleman trying to trick him. And he was clear. In 2014, he had no idea she was behind it. No matter how many ways she tried to ask the question. You saw him explain all the wires. I'm not going to do it here. I won't do that to you all. You saw him explain every word on Dolce Vita. You saw him explain what Dolce Vita was about. See, what you learn is that he met with his mom. And at first, he thought this might be the same original extorter because he knew that Catherine and Sigfredo were having issues. And that made him nervous. But he also saw how different this was. And I apologize. I went over so many wires where it's the same thing over and over and over as to him trying to compare the two events. I did it for a reason. It wasn't to bore you. It was to show you in real time what was on his mind. And when he met with his mom, because of the differences, he was pretty certain it was the police. And he had no clue who Tato was. But then he meets with Catherine Magbanua in that car, and he freaked out. And you know why he freaked out? Because he learns that there is a Tato. He learns that he is not only in the Latin Kings, but is the head of the Latin Kings. He learns that he has brothers. Remember the bump? My brother is incarcerated, And he learns that Tato is incarcerated. And he thinks to himself, oh my God. And by the way, he also learns, which we now know is a lie, because again, Katie was trying to protect Sigfredo. He learns that Tato was the killer. He wasn't the killer. Sigfredo was the killer, Tuto. But in the car, he learns about the Latin kings, he learns about Tato, and he learns that that is the guy that she told him killed Professor Markel. And you wonder why he's talking the way he's talking at Dolce Vita. He is freaking out. He thinks his mom, if they don't pay, is going to get killed. And if she doesn't get killed, someone else is. And so when they walk into Dolce Vita, that's what the debate is about. So you have to understand the context of the conversation. When they're talking about rental cars, it's because he's just learned about the rental car. When they're talking about dead gang members, it's because he's just learned about a gang member, Tato. And the debate is he wants her to pay. And she's telling him, it's not them. It's not him. And the reason why she's telling him it's not him is because she knows who Tato is. You saw Tato. He'd be a little bit more threatening than the guy we saw in the video. And his associates would be a little bit more threatening than Mr. Jimenez. And through Dolce Vita, what you see is a couple things. And you can listen to it. Don't take my word for it. You see him trying to act tough. But then you see him quickly say, but I don't know anything. I'll keep my mouth shut. So he's acting tough. I'm carrying a gun. I'll shoot the gang member in my driveway, but I don't know anything. I'm keeping my end of the bargain from July 18th. I'm not going to say a word. This discussion about information and details. It's clear on Dolce Vita and on the liars what they're talking about. The details aren't details about a murder. The details are details about the payments. By the way, that's what they talked about when Jimenez came and did the bump. We know you've been helping. The payments. They leave out the fact that repeatedly he says, I don't care if it's the police because I've got nothing to hide. It's said in Dolce Vita. Discussions about the importance of the characteristics of the guy who approached them. He's not using, he's using a real phone number. He's not wearing a disguise. He's not giving 48 hours. He's not being threatening. Again, we talked about it. They only know part of the story. Discussions about who he hopes it is. Hopes it's the police. And you see that contrary to what Ms. Cappleman said in closing, his absolute first instinct is to pay. He wants her to pay. She doesn't want to pay. See, she knows it's not Tato. She knows it's not Sigfredo. And she's trying to convince him it's the police. And you'll see in the video, she goes to the bathroom. And by the way, he's been talking like this. He doesn't stop. She goes to the bathroom and he finally listens. And when she comes back, you see his conversation changes again. He says, okay, I see what you say. Here's the number. Call the number. But he starts talking about how it's different. And then he calls his mom and he talks to his mom about how it's the police. And Matsuri is the same thing. Now, why they're talking in code, listen, I think this is semantics. There is no code, but we can agree on this. They are talking carefully. And the reason he is talking carefully depends on who he is speaking to. When he's speaking to Catherine Magbanua, he is speaking carefully because he needs her help. And he does not want to spook her. When his mom and him are speaking carefully, it's because he does not want anyone to know, including the police, about the first extortion. Because if they know about the first extortion, they're going to come talk to him, and he believes that he and his family will be in danger. And by the way, he doesn't go to the police because it's clear the police wouldn't believe him. Just like they don't believe him right now. Now, during Miss Cappleman's cross of Charlie Adelson, you saw it. I'm not going to go into it in detail. But one thing is clear, is that he knew the wires cold. He knew dates. He knew what he said on particular wires. And you might ask yourself, why? His life is dependent on those wires. For the last year and a half, he's been in prison, jail. He's reviewed those wires because he knows they show what really happened. The wires show his innocence. And they certainly don't show proof beyond a reasonable doubt of his guilt. You know, like the landline, I want you to think about the bullet bourbon. Agent Maltese was told to take a picture of that bullet bourbon. Done to incite. Thank God Wendy Adelson kept the invitation to the party. Not the simplest explanation, but the truth. The state's case is like that. The case against Charlie Adelson is a case of guesses and of assumptions. It was not brought until just weeks before Catherine Magbanua's second trial. 8 years after the murder, 6 years after the arrest of Sigfredo, and later Catherine Magbanua. The evidence wasn't there then, and it isn't there today to meet their high burden. The puzzle pieces do not fit. He did not participate in the murder of Professor Markel. He didn't do it. He didn't conspire to do it. He didn't solicit it. By the way, speculation can be reasonable doubt. You can go back there and speculate. You can use your common sense and figure out.
Your Honor, misstatement of the law.
Right.
You knew that was going to happen. And he made another major faux pas. He told the jurors that his client's been in jail for a year and a half. Courts go to great lengths when people are in custody to dress them in suits so the jury doesn't know they're in custody, because if they're in custody, it's inferred they're bad guys and they don't make bond. He admitted to the jury that his client's been in custody for a year and a half. The judge looked up and was like, I can't believe you just said that in front of this jury. Major problem.
Is that an appellate issue?
It could be ineffective assistance of counsel on appeal after all of his appeals are done.
I'm just taking notes on what you said. Tim, what's going on right now? What was this latest objection?
Well, remember I told you when she mentioned speculate, and I thought he was going to give a curative instruction? Well, he just came out here and told them they can speculate, which is not the law. She objected. They're gone to sidebar now. And I guess he felt like he could say they couldn't do it. I don't know what the judge is going to do.
Speculation. You may continue with your argument.
You're allowed to use your common sense.
He's been overruled.
That's what you're allowed to do. That's what you're told to do. You don't have to check that in the door out there. The presumption of innocence means that we presume the best about people. We presume them to be blameless. That means when you're listening to these wires, if there are two possible explanations, you go with the one that is favorable to Charlie Adelson. That's what is consistent with the presumption of innocence. The state wants you to assume guilt. They want you to listen to these wires, and they want you to hear them in a certain way through dirty lenses. They want you to look at them through the lens of everything being wrong and sinister. That is not what the law says you should do. If you presume this man innocent, which the law says you must do, which is what each and every one of you gave your word you would do during jury selection, then you look at these wires and you listen to them assuming the best about Charlie Adelson. And when you have two explanations, both of them reasonable, you go with the one that presumes his innocence. That's how our system works. Reasonable doubt, the judge has instructed you on. And he's told you that reasonable doubt is if you vacillate, if you go back and forth, that either explanation could be right. If you waver at all, that is living, breathing proof of reasonable doubt. And when you find yourself doing that, you must find Charlie Adelson not guilty, because that is reasonable doubt and shows that the state did not meet its burden. Each and every one of you promised us during jury selection that you would have the courage, the fortitude, that the prosecution didn't meet its burden, something they have not come close to doing in this case, that you would have the courage to say the words "not guilty." And that's what we're asking you to do, because simply put, the evidence isn't there. The evidence is actually consistent with innocence. Now, because of the state's high burden of proof, they get another closing. And I don't get to speak again. So I need each and every one of you, when they're speaking, to think in your minds, what would Rashbaum say? What would the evidence say? Remember, in our system, they don't get the last word. You do. I know you will take your jobs as jurors seriously. I know you will follow the law, the presumption of innocence, and the high burden of proof. If you do that, there is only one just verdict in this case. Count 1, not guilty. Count 2, not guilty. Count 3, not guilty. End this nightmare. Send him home. Thank you, Your Honor.
State prepared to give its rebuttal closing.
Yes, Your Honor.
You may proceed.
He doesn't know when to stop. He lost the jury 45 minutes ago. He had to know it by looking at the jurors. He continued and continued and continued. Brevity is always rewarded, and it's just painful.
Encouraged you to speculate in this case. The law does not allow that. I want to draw your attention to page 4 of your jury instructions. You'll have to pick them up. Page 4, middle of the page. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt. Could it be? Not good enough. A speculative doubt. Speculation. Don't have that in the courtroom. We don't have that in the jury deliberation room. Imaginary or forced doubt. Not reasonable. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. When you're back there and you're thinking about what Mr. Rashbaum would have said, he would have said puzzle pieces. First puzzle piece, the motive doesn't fit because he had a great life and he wouldn't have wanted to ruin his life. The problem with that argument is arrogance. This was not an issue for him because he wasn't going to get caught, because he was untouchable. They said relocation had no impact on Charlie Adelson, and that they proved Wendy's innocence in their questioning of her. Why are they working so hard to convince you Wendy is innocent? Does it matter? Y'all aren't being asked to decide anything about Wendy Adelson. There's nothing on that verdict form about Wendy Adelson. Did she corroborate the defense theory in this case? Wendy Adelson testified she didn't know anything about this supposed extortion of her brother, even though she moved there the day this happened. She didn't know in 14, she didn't know in 15, and she didn't know until it was announced in opening statements in this courtroom. I asked her about it, and she said, quote, well, I learned that someone made that argument. I don't know whether it's true or not. I don't know whether it's true or not. Even his own sister doesn't believe this load he's trying to sell y'all. Garcia wanted to kill the defendant, so he wouldn't have done a hit on his behalf. And for that, they referred to the jet ski incident. They couldn't be in a conspiracy together because they hated each other. Well, that was part of the purpose of the walling off. The whole theory of this defense is that this defendant was so fearful of Sigfredo Garcia that he couldn't do the normal thing. He couldn't report this. But he continued to date Catherine Magdanois, Garcia's baby mama, after all this. After July 1, when they had this incident in the roadway. After the extortion. And even after that, he continues to send love notes to Sigfredo Garcia's woman. Even after the two of them get back together, he's still sending those notes because he's so arrogant. Defense has told you that the defendant made the joke about the TV being cheaper than Hitman to people he hardly knew. Who are those people? The only person that testified in this courtroom that they had heard that joke was Wendy Adelson. Lacasse was asked. The lawyer said they said it, but and you guys have to refer to your notes and your own memories about what the evidence showed. But Lacasse was asked, did he say the joke at the dinner that y'all went to with Wendy and Garcia and Catherine McDaniel. I'm sorry, Wendy and Charlie and Catherine McDaniel. And he says, no. He does not recall that joke being made, and he thinks he would have recalled it had it been made. So there is no evidence in this trial that the defendant told that joke to people he hardly knew. If this was a murder for hire, it should have been paid in advance. Murder for hires always get paid in advance. That's what Pat Sanford said. That's not what he said. What Pat Sanford said is the arrests have been made close in time after the other murder for hire cases have worked. So there's no payment over time, gifts and stuff like that. Here, the investigation took years for the defendant to have the opportunity to try to keep her happy, to try to provide these gifts, not only to her, but to Sigfredo Garcia, a gift card for a vacation on your extortion victim. Offered, not asked for, not demanded, offered to the extortionist. The defense talked about Catherine McDaniel. He hates when people lie, and she's a liar, and she lied to you. Well, Mr. Rashbaum's opinion about the witnesses, he told you which ones were good, which ones were lying, which ones were truthful, which ones were the best ones, which ones meant nothing. You guys decide that stuff. Okay, what we say is not evidence. Catherine McDaniel is a liar, though. I mean, she said other stuff, and now she's saying this. You guys have to consider that. That's a no-brainer. She has played every card she had, and this is the last stop for her. I agree with that. You guys agreed at jury selection that you would keep an open mind to that type of evidence, and that's all I ask you to do. Does it fit with the other evidence in the case? Because her last testimony sure didn't. Nobody has stronger feelings about Catherine McDaniel than the ones sitting on this side. Would I ask you to base this defendant's freedom on the word of Catherine McDaniel? That's what they said I'm doing. And I would never do that. Never. Does it fit with the other evidence in the case? That's what I'm asking you to consider. I didn't ask her about Dolce Vita. She verified the transcript. She said the words that scrolled when y'all watched it were the words that were said. The state has a doubt. What if we do? It doesn't matter. Doesn't matter what the lawyers think. Doesn't matter. Do you have a doubt? Doesn't matter what I think. Doesn't matter what Mr. Rashbaum thinks. Regarding the defendant's demeanor in 2014, the defense said there was nobody that said anything about his demeanor. We only asked about, was he going crazy after the bump? And the answer was yes. That's not true. Ryan Fitzpatrick, who was his best friend in 2014, they didn't fall out until 2015, reported no change in his behavior. I said, was his behavior weird like that before the bump? No, not weird. That was his quote. He was normal until the bump, and then he was agitated, angry, freaked out, tense, stressed, whatever. Why didn't I play all of the calls? Did y'all get enough of the calls? It's trying to pick the parts that I think are important. They're in evidence. Feel free to listen to them. I do not want you to think I was trying to hide anything from you. Those are in evidence. And you will have an opportunity to review anything you want when you're back there with the recording equipment, headphones, and all that will be provided to you. The defense says in calls A, B, and C, if you did a murder with someone, wouldn't it be the first thing on your mind to report? Well, maybe, but you're probably not like Charlie is. You're probably not untouchable. Charlie Adelson asks the description on the wire, tell me about this guy, what's the timing, what was he wearing a disguise? How do those questions, the defense is offering that as evidence that he was trying to deduce whether this blackmailer was the same as the prior blackmailer, but he never saw the prior blackmailer. He only saw Catherine Magbanua. So how does asking if the guy that approached his mother was wearing a disguise tend to prove his innocence or tend to prove his extortion theory? The guy that extorted him wasn't wearing a floppy hat and an Abe Lincoln beard. It was Sigfredo Garcia. It was Catherine Magbanua. Sigfredo Garcia, the first extortionist, didn't give him 48 hours to pay. He put him on a payment plan. He paid over years. The defendant, hoping it's the police, and saying, quote, these people only know part of the story, or they think they know part of the story. The defense picks that out and says, oh, there he is talking about the first extortion. Or is he saying, why did they go to my mom instead of me? I'm the one that has a connection to you. I'm the one that, I think what he says is, I'm the one that has a relationship to you. Why didn't they come to the one that's involved? I mean, I'm not involved. That's what he says. Why didn't they come to the one that was involved in this? That's what he's trying to figure out about why they went to his mom and not him. Can't even read my own writing here. Oh, the PowerPoint with Wendy. Okay, the dots on the cell phone PowerPoints do not indicate where the person was. They indicate the cell tower that was servicing the person's phone at that time. So they're going to be somewhere around there. And the testimony was that Wendy's dot at 12:30 could be consistent. He can't say where she was. Could be consistent with her being at Trescott. And we know she went to Trescott because Officer Green observed her there. So I'm not desperately trying to pound a puzzle piece into y'all that Wendy made the call to say it's done. I don't know that. I can't prove that. If that information was conveyed, I don't know how it got conveyed. All right, Lacoste. They really need y'all to discount the testimony of Jeffrey Lacoste, right? Because of that statement that Wendy made to him just before the murder, that all kidding aside, her brother really had looked into hiring a hitman to kill Dan Markell. And the defense says, you can't believe him, he's a jilted lover. And the evidence definitely showed that he was heartbroken over Wendy Adelson. But unfortunately for the defense, his brain was working just fine. And he testified about Charlie Adelson bragging in the hot tub about connections to a Cuban criminal element. The defense says, oh, they're not Cuban, that's not in evidence. They're of Hispanic descent, and he reported that to law enforcement that that's what Charlie said. Lacoste doesn't know if they're Cuban or something else. Lacoste said he bragged in the hot tub about having connections to a Cuban criminal element, and when Lacoste reported that information, the killers had not been identified, so he had no way of knowing if they were Cuban or of Hispanic descent. That's the importance of that. Lacoste says Wendy reported the celebration dinner, same thing. He comes in and tells the cops, look, she reported a celebration dinner to me where she vomited on the table. An inspection of the records proves there was a dinner and she did vomit. But they want you to believe that Lacoste is just lying about the celebration part. The Halloween text. They've asked you to look at their piece of evidence that talks about when Garcia learned about the existence of Charlie. That doesn't shed any light on what we're saying occurred on Halloween. On Halloween, Charlie, this defendant, approached Catherine Magbanua about, do you know anyone that can rough him up? Okay, we're not alleging that she called Garcia that day and said, hey, can you come kill somebody? That was just the first inquiry into a plan that developed over time between Charles Adelson and Catherine Magbanua. All right, the defense mentioned Erica, and I'm almost done. Erica Johnson and her testimony, that didn't mean anything. Why did they call them? What about that recorded call between the defendant and Erica? Why does he tell her not to talk to the police? What about June and Chinda? Why does he tell her not to talk to the police? They don't know about the first layer of extortion. They can't reveal the first layer of extortion that will reveal the second layer of extortion that will expose him to the Latin kings. Why is he telling them not to talk to the cops? Defendant's testimony. They say it's reasonable that he didn't go to the police with the truth because he had just seen what these people were capable of. They killed Dan Markel. He was in fear. Okay. Is that consistent with what you know about him? I refer you back to the wires and everything you know about him. But also, why then not come forward with this story when the bad guys were arrested and the danger was eliminated? Why not come forward when Catherine McDaniel was arrested and he believed her to be innocent? For 3 years, she awaited trial while this man thought she had nothing to do with it, according to him. Yet, he did not come forward with this story. Why not come forward after her conviction? All the bad guys have been arrested and convicted. Danger eliminated. Come tell the truth. He doesn't do it. What about after his own arrest? He doesn't come forward then. We learn it in this courtroom in opening statement. Defense says the defendant freaked out in the car before Dolce Vita. You have to watch Dolce again and see if you think he was freaking out or if he was in control of that situation. He was the one giving orders in that situation. I'll go back to the players in this case being smart. I mean, the defendant is smart. And they had over a year to carefully plan this murder with the goal of not getting caught. And he's had 7 years to think about his defense in this case since the case first broke. And he does think he's untouchable. Don't guess. Don't assume. Look at the evidence. It will tell you everything you need to know. But don't let the way the defendant thought he would get away with this be the reason he gets away with it. As long as you keep your mouth shut, you can get away with murder. Well, fortunately for us, the defendant didn't take his own advice. He did take the witness stand. He did offer statements, and you are able to assess his credibility as part of your determination of this case. Only one of us is putting on a magic show. It's up to y'all to figure out which one it is, right? We just hope and trust that you all have the common sense and the courage to see this case for what it is, to cut through all the stuff that the lawyers say and get to the meat of it and render a verdict that does justice for Dan Markel. And that is a verdict of guilty as charged. Thank you.
In just a few minutes, you will be taken to the jury room by the bailiff. The first thing you should do is to choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back into the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave your devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in any note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The audio, cell phone, summary, disc, jump drives, photographic, and video exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please request that in writing. In closing, let me remind you that it's important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Before the bailiff takes you back to the jury room, I'm going to have the clerk announce our alternates, and they will be dismissed at this point. I did want to say, though, to our alternates, I thank you for your diligent service throughout this trial. This is certainly a circumstance where 2-week trials are not the normal, but we thank you nonetheless for your service in this matter. Madam Clerk? Your belongings. If you wish to know the outcome of the trial, you may contact my office and we will respond. For the rest of the jurors, you may take your notepads with you. Please leave the copies of the jury instructions, but you may take your notepads and I believe your audio recording lists as well. This would be the point where everyone rises for the jury.
So now we need to know who the alternates are from the people in the courtroom.
I'm going to find that out. Is that normal protocol to release them right now?
Yes. They cannot go back in the jury room. Only 12 can go in and begin deliberating.
So I believe the one juror that we were all questioning, Katie Kool-Aid referred to as businessman.
Yeah.
Everyone can be seated.
Said he just left, so he was an alternate. So
he was. I figured he was.
He was an alternate. With the clerk.
Questionable juror was an alternate.
In recess, unless there is a note or we have a verdict itself.
Curious to see how long he'll let him go. Rashbaum's going to go.
Leave your phone numbers with the clerk. We're in recess.
Now they got to go make sure all the proper evidence that's been admitted goes back to the jury. And that can be a problem. You got to make sure only the stuff admitted. So both lawyers will go up to the podium, go over it with the clerk, make sure that what's been admitted is only goes back to the jury. How
long a process is that?
That could take a while if you got a lot of exhibits, but if the clerk is good and the parties that Sarah's probably been keeping track, so Rashbaum or misused, will go up there and make sure that the proper evidence goes back. It can be time consuming.
So what's going on here? Tim, that was
I think that's George's mom right there.
Yeah, George's mom. There's Carl Steinbeck, John Steinbeck. Carl Steinbeck been feeding me some information. He flew in for this. Thumbs up from Sarah Dugan to Georgia Cappleman.
Yeah.
There's Phil Markell speaking to someone who I do not know who that is. They may have additional family or friends that came in. They had one very close friend. By the way, that is the Court TV pool camera guy in that corner there. He's been doing a lot of work. He gets credit for a job well done, despite some of the crackling audio.
They do their best.
Tim Jansen. So that, by my account, was about 5 hours for closings. That seems long, is it?
It was. Was it that long?
It-
9? What time is it now?
It's almost 2. We started 8:45, 8:46 when we gavelled in. So a little under 5 hours, but roughly 5 hours.
Well, we kind of talked about Georgia's original opening, right?
Yes. So
And so we could talk about Daniel's closing. I think Dan started strong. He used Occam's razor against Georgia, which was the simplest thing. I thought that was pretty well done.
Tim Jansen, here's a poll, an STS poll coming in hot.
Yeah.
Charlie Adelson will be found guilty, 85%. Not guilty, 4%. Hung jury, 11%. So that is what STS Nation is saying. Tim Jansen, go ahead.
That's pretty consistent. So when most of his defense was beyond a reasonable doubt, right? He said they couldn't reach the burden. He only said his client was innocent when the last thing he said. He didn't, in his last, why would he finish? He's innocent, but he never said that the whole time. He said they haven't proven it beyond a reasonable doubt. So they're not saying he didn't do it. He, in effect, is saying they didn't prove it beyond a reasonable doubt. That was most of his argument through his closing. And go ahead.
No, I agree with you. He did bring up Occam's razor at the beginning, which is basically the theory that the simplest answer is the preferred answer. But then he said Occam's razor is a guess. We don't guess in the courtroom. He says we presume them to be innocent. And he says sometimes things aren't so simple. So, yeah, that was the beginning. And, Tim, I thought that was reasonably effective because it makes you question it. But to your point, 30, 40 minutes in, let alone 2 hours, I was getting notes from people in the gallery, and they said that he had lost the jurors. How important is it when you're a defense attorney to read those jurors, to know, okay, I've got to wrap this up a little faster?
I will tell you, when you're up there arguing, you know when you lost a jury. You know within like 20 minutes if you lost them. And I don't know if he just had his notebook, he had his script, he wanted to go through it, but it was painful that he wasn't making points. He was belaboring the point. He lost me when he said Jeffrey Lacoste was not believable, because I think he was one of the more believable witnesses in the whole trial.
100%.
He admitted he was pathetically in love with Wendy. He said that he had notes. He said he was in fear. I think he was a credible witness, and I think the jury's going to find him credible. Another major problem I had, he knew he had a problem with them talking in code. And at the end, he goes, they're talking in code. They're talking in code. That's just semantics. That's not just semantics. That's criminal behavior. That's what co-conspirators do. And he did it to Catherine because he didn't want to spook her. And he did it to his mom because he didn't want them to talk about the murder. That's just not believable.
There was also a little bit of arrogance at the end of his closings here. I took some notes. He goes back to the whole puzzle pieces theme. But at the end, I personally never would have said this, but he did. He invoked, what would Rashbaum say? It's almost like, what would Jesus do? Not a good phraseology there, I don't think, by him. And I just think it kind of speaks to his disconnectedness from this Tallahassee community that's very down to earth, reasonable. And he's in there saying, what would Rashbaum say? I don't know. Did that strike you as strange?
Yeah. And, we knew, Singer and I agreed, we knew he was going to attack Meg Banowa. We knew that was going to be a key of his defense because, listen, he had to tap dance around the recordings, the conversations, the coded calls. He had to tap dance, but he could really focus in on Meg Banowa, especially when she gave lies. And he tried to make that probably a lot of his, maybe a quarter of his arguments. You can't trust Meg Banowa. And I think Georgia came back and said, listen,
I'm not asking you to convict on Magbanua. I would never charge anyone based on her testimony alone, which I thought was a good comeback.
Tim, what's the protocol? Because I did not hear the judge give any kind of instructions about a possible, if a verdict was to come back today, what is the typical protocol? What kind of warning does the court give the public?
Well, he doesn't give the public anything. He tells the lawyer, you give your cell phone to the clerk. You make sure you're within 10 minutes of being back in the courthouse. So Georgia will go to her office. Rashbaum will, if he doesn't have a place, he can hang out in the courthouse or somewhere close. We don't know how long they're going to deliberate. The judge is going to concede. He's probably got them lunch right now. They probably aren't even going to start deliberating for another hour or so until after they eat lunch and use the bathroom.
Rob D, Tim, how late can and will the jury deliberate today? And if you have questions for Tim, now's the time. Funnel them in. I'll get them to Tim. We'll go a little bit longer. And then just so you know, we are on verdict watch now. We have people in the courtroom. We will get a warning, I hope, I pray. And we will be live with the verdict. We will get some sort of warning, and we will be live with that. We're planning a regular show today, FYI, at 5 p.m. Eastern Time. 5 p.m. Eastern Time. We're going to be joined by Tim Jansen, Katie Kool-Lady, Carl Steinbeck is coming on, and Richard Gabriel, who's one of the best jury consultants and understands juries better than anyone. He's coming on, all of them, 5 p.m. Eastern tonight. John Singer was supposed to be on, but has a conflict, so he'll either be on later if there's a verdict after that, or he'll be back with us tomorrow. Tim, it was a lot to take in. I'm looking here for some questions from the jurors, but I am also looking at my notes. At one point, Rashbaum said that Georgia mocked the notion of murder by layaway, and she probably should have. Why would he even bring that up? He says, and he went on to say, extortionists do work on payment, and his proof of that was Katie Magbanua. I don't think anyone's buying that.
He took some personal attacks at Georgia, which doesn't make him look good. Because remember, she's the prosecutor. She's wearing the white hat. She hasn't really attacked anybody. She attacked his arguments in closing, but she never personally attacked anyone. And when he attacked her, you lose points with the jury. You really do. And what would Daniel Rashbaum do? That was inappropriate.
Well, it's like kind of egomaniacal to a client that he's defending who's supposed to be a narcissist. I don't think that helped. Tim, there was a question earlier, and I had pulled up, which was along the lines of, can the defense, this person wanted to know if the defense could have waived his opening statement, could have passed on that and just saved stuff for closing. Is that possible in Florida law?
He can waive it, and he can give his opening after the state rests, and then he can give his opening, and then he could have called his witnesses. I've seen it done. I've never done it because I don't like to wait that long. Jurors, make their mind up. By the time they get to your case, they've already
dug into their position and they may not listen to you, but you can do that. He didn't do it.
He also said repeatedly, there's plenty of reasons not to like Charlie. I get where he's going with that. I understand it. He says it doesn't make him a murderer, but he's also subconsciously, egging on the jury to dislike this guy. That's kind of a double-edged sword, isn't it?
It is a double-edged sword. You might not dislike him, but Rashbaum had a kind of an arrogance to him also. His closing was a lot of screaming, a lot of high pitched. He did get away from the podium. He wasn't relying on notes. He knew his points. He just went on too long. He should have saved his best points and made those points and moved on. I think he alienated the jury by going verbose. Apparently, jury watchers said that people were folding their arms, they were cleaning their glasses, and they weren't even looking at him. You know that when that's happening in closing.
Yeah, we're getting a lot of reports. And by the way, one of the reports we got, Tim, I'm interested to get your take on this, was that during Daniel Rashbaum's closing arguments, Charlie tried to hand him a note, and Daniel Rashbaum saw it and brushed him away and even said something to him. The jury's watching all this. I mean, what could he have possibly been handing him in the middle of closing arguments? What would you do in that situation?
You would not go over to him. You would hope the lawyer sitting there would have brushed them off. Clients always, I mean, it's their case, but they don't realize that you're focusing, you're doing your thing. You don't need interruption. And it's really too late at that point, because all you now is make an argument. It's not evidence. And you don't want to interrupt your lawyer. And you don't want to make it look like your lawyer is not saying what he should be saying, right? He's making his lawyer look bad in front of the jury. And it also makes it look like maybe he is in control of this whole defense. Maybe he is. It was contrived, and maybe Dan forgot something.
Here's a question from Betty Boop. Question for Tim. Can the alternates be interviewed now to get their case on the trial?
They can. Usually the judge tells them not to until the case is over, in case someone gets sick or they have to kick somebody off the jury. I've seen alternates come back and watch the verdict. And I've seen alternates give interviews, for sure.
I mean, what if hypothetically someone got 103 fever with COVID tonight and they were deliberating tomorrow? They'd bring back one of the alternates?
For sure. Yeah.
Okay. So that's how
And
it
that
works.
juror would have to say that they didn't read anything and they didn't talk to anybody, and and all deliberations would start from scratch.
Wow. Interesting.
With that new person. Yeah.
Wow. Adam Lamparello, how can Charlie, Tim, simultaneously be convicted of first-degree murder, conspiracy, and solicitation? Isn't that logically inconsistent?
Well, you can't. So remember, conspiracy is just the agreement, right? You conspired to hire someone to kill someone. Under the principal theory, he could be convicted of first-degree murder. And solicitation is just seeking to hire someone. Now, they probably won't get a conviction on all three. And if they get a conviction on one, they'll probably throw out the others because of sentencing phase. First degree would be mandatory life. I believe conspiracy to first-degree murder is probably mandatory life. So if he gets convicted, he's going to get mandatory life sentence.
And how soon would the sentence be handed down after a guilty verdict? How do they work in Tallahassee?
Normally, if you don't have any prior record, you're entitled to a pre-sentence report. But in this case, where there's no sentencing discretion by the court could do it pretty quickly. He might want to wait to allow the victim's family to give they have a right to speak to the court before sentencing. So it may not be immediate. They may wait a week, but they don't need a report.
Katie Cool Lady, happy birthday to you. She's going to be coming on the show. She's going out to a birthday dinner, which she deserves, but because we're on Verdict Watch, she's going to try to come in here. This is interesting. Tim, how does this work? Smith says, I'd love to see the indictments that come from the testimony. Do they, build indictments off of this type of testimony to take down someone like Donna Adelson next, possibly?
Well, now what do we have? We have the testimony of Charlie Adelson that's not immunized. So they can use that testimony and decipher if they can take derivative use of it. Now they know, or maybe know, what Donna's defense is going to be, or allegedly going to be. And then they can determine, well, maybe we can use something here. We have enough here that we might be able to charge Donna. It's interesting. That's an interesting thought.
Yeah, and some people are betting that might happen sooner than later. A couple more quick things with Daniel Rashbaum's defense, and we'll pivot to the rebuttal, and then we'll let Tim go and have his own lunch, and then we'll come back. We'll be on Verdict Watch, and we're having a show either way, 5 p.m. Eastern time tonight. But Rashbaum went on to say, Tim, a couple of things. He said, and I quote, "It's amazing to me that the state still doesn't understand what happened." Again, very condescending kind of in nature. He then went on to apologize for his tone of voice when he was interviewing or had Katie Magbanowa on the stand, which is sort of an admission that he's annoying when he raises his voice. Went back to the puzzle pieces a bunch of times. The one line that really made me kind of laugh a little bit out loud is he said, and I quote, "I hate when a murderer comes in here and lies." And he was talking about, of course, Katie Magbanowa, but most people think he could have been talking about his own client. So, Tim, how careful do you have to be with kind of the turn of phrases that you come up with in court? Because that really backfired on him, I think.
It did, and I thought Georgia was going to hit it on rebuttal, saying, yeah, even his own lawyer doesn't like murderers who lie. Ladies and gentlemen, you've heard the testimony. You make your decision, but his story doesn't add up. It looks like he's lying, and we know he's guilty of murder. I like when she turned and said even Wendy didn't buy his defense. In the rebuttal, she said Wendy doesn't even know if it's true, and she saved that for the end. This so-called defense, she didn't know about it until she got there, and that's a strong piece of evidence.
Yeah, she didn't know. I mean, that's crazy. He also went on to say we're almost done, which is an indication that he knew he was boring the jurors.
Yep.
Later, he says he put on the wiretaps and it wasn't to bore you. Again, basically hinting that I'm boring you. What about the fact some people said it was kind of a word salad. Like he was just talking and talking and talking. There was no real evidence, no graphics, no wiretaps, no phone calls. Have you done that, Tim? Like just to talk circles into someone thinking there's reasonable doubt? Was that a possible strategy?
It's not effective. People stop listening after a little while. They like graphics. You can get their attention if you say something and they can see it. He was kind of meandering all over the place, but he kept circling back to Kathy Magbanowa and her lying. I just think he lost effectiveness. He started off strong. He was passionate. I'll give him that. But I think he put the juries to sleep. And I'll remind, I had a judge one time, I was arguing a motion, and he said to me, Mr. Jansen, we both have two jobs. You have to speak. I have to listen. I want you to know I'm already done, but go on. And so I immediately stopped my argument at that.
Again, one other huge highlight, and you brought it up, was Daniel Rashbaum. I guess he slipped and said that to the jurors that his client was in jail for the better part of last year.
Yeah.
How big a deal is that going to be inside of the deliberations room?
You know, they do that mostly for a lot of indigent clients or mostly clients who are in custody because they're not bond, because you don't want the impression that they're dangers. That's why they can't get a bond. So you go great lengths always bringing him in before the jury. He's in a coat and tie. He's dressed in a coat and tie. So you never want, I don't know if these jurors know he's in custody, but why would you as a lawyer say he's been in jail for a year and a half? I mean, it's his own making. He can't say the state said it. He said it. The state didn't say anything. They didn't even respond to it.
Jack Watts, this podcast is 1000% prosecution. Why? I don't necessarily agree with that. I just think that the evidence is pointing that way. Tim Jansen, you want to respond to Jack Watts?
Listen, I was a federal prosecutor for 5 years. I've been a criminal defense lawyer for 30-something years. So if there's anybody going to come in here and tell you they haven't met their burden, I would tell you that. It's a strong circumstantial evidence case, really strong. I was curious to see what the defense was going to be. And while the defense might fit every plug and hole, it's just not reasonable. And it's completely inconsistent with his behavior. He didn't tell anybody about this. He never mentioned the extortion, didn't mention his sister, the extortion. And I mean, I'm going to come on here and call balls and strikes. I don't think it's credible. Now, someone might find it credible. If he had a credible defense, I would say that, but I don't believe there's reasonable doubt.
Mary Griffin says, Tim, I'm going to miss seeing you every day. Thank you for an awesome job. Tim's going to be back soon enough for another trial. We're going to continue to do these, not every week, but we're going to find big cases and we will watch them together as we move forward. Tim and I are working on that as we speak. To the rebuttal now. Let's go through some of it real quickly.
Oh, by the way, I have said multiple times they don't have enough to charge Wendy Adelson. I've
Yes.
said that multiple times.
Yes, that is true, and I've been there for that. Question for Tim. I don't know what this is. Did the defense cross the line when he pointed about the prosecution trial strategies, especially knowing that the state can't say that Charlie's parents are not here to support him?
He pointed. Oh, they don't believe. Is that when he said they don't believe in their own case, or they don't believe? Was that what the point
I'm not
was?
100% sure. Studi, if you want to clarify that a little bit, and then we can come back to Tim. But Tim, Georgia Cappleman said that, there was this whole notion that Rashbaum raised. Why would he ruin his life? He's this successful dentist. He's got money. He's got women on the side. And she said that ruining his life was an issue of arrogance, that you can be smart, you can be successful and be arrogant. And then she went on to say that he didn't think he could be touched. I thought that was strong because that was a lot of common sense right there.
It is. How many people who have everything in the world in their hands, living the fancy life, do something that's so stupid? Look at these NFL players that are making millions of dollars, and they go drive drunk and kill somebody 150 miles an hour, and their life is, they're going to prison for 15. Everything is lost because they did something stupid. I think it was pure arrogance. I think mother was pushing him, and he's always looked after Wendy. And I think that one comment on that tape, Wendy doesn't realize how lucky she is. And they're both lamenting because they're going through this and what they've been through. Wendy doesn't realize what we've done for her. And I think that is so apparent of their guilt.
So Georgia went on to say the whole theory is that this defendant is so fearful, Charlie Adelson is, of Sigfredo Garcia, but then he continued to date Katie Magbanua after all this, and they're sending kissy notes. And he says it was just pure arrogance. Again, I thought that was a good point. And then the defense said this joke about the TV was told to people he hardly knew, about hiring a hitman would be more expensive. A TV repairman would be cheaper than hiring a hitman. And Georgia made it a point to say that the only person who testified to this was Wendy, and that Jeffrey Lacoste had never even heard about it. Here's a question from Hart Matterhorn. If Charlie was arrested when he should have been around the same time as the other killers, would he have been able to craft this defense, Tim Jansen?
Probably not. He wouldn't have had everyone else's testimony. He wouldn't have had all the transcripts. He probably wouldn't have all the wires. Now, remember, his lawyer was involved. His lawyer watched the Magbanua trial. He was up here watching it. And so I don't think so. The timing, yeah, I thought Georgia did nicely at the end when she said, you didn't mention this when so-and-so got arrested. You didn't mention it so-and-so, and you didn't even mention it after you got arrested. And Dan tried to say, well, they wouldn't believe him. Well, maybe they wouldn't believe him, but at least if he'd have told him when it happened, he'd had a better chance. That's like when you have a stand your ground self-defense.
Yeah.
When you kill someone and you leave, your defense is a lot less than when you stand there and say, yeah, this is why I was in fear. I shot myself. Then make it up later on,
Yeah. Georgia closed out with Charlie's very smart, no doubt about that, but that means he had a long time to plan all of this. And she went on to tell the jurors that you can assess Charlie Adelson's credibility inside that deliberations room, which I thought was interesting. And finally said, only one of us is putting on a magic show. Only one of us is putting on a magic show. And that hit hard with me. How would you grade Georgia today with the closing and the rebuttal, Tim?
I mean, she kept it quick. She knew that the jury was worn down. I've never seen a judge do that to a jury where they don't give breaks. They don't give them lunch. He could have certainly cut those things off where they would have been more fresh. I think it probably hurt both sides that the jurors were ready to go. I think Georgia did what she had to do. I think Dan went too far, too long. And I think Georgia kept it short, quick at the end. I liked her last thing. Only one put a magic show on. You decide which. She knows. She's watching that jury. She knew if he was making points. They're watching if they're taking notes. She didn't have a lot that she had to fix because she doesn't believe the jury's buying it.
Linda Lou says, and then we'll wrap it up. Friday, I was sure he would get away with this. Tim, what about the undulations of a trial, the ups and downs? 1 minute you can think the defendant is in the clear, the next you think he's getting convicted. Is that kind of a normal roller coaster feeling?
It is. And I can tell you, when Dan sat down, he probably thought he's got a not guilty. And after Georgia did her closing, he probably thinks she's getting convicted. It's kind of like taking the bar exam. As soon as you get done with it, you think you failed it. When you talk to someone else, like, oh my God, I definitely failed it. It's just that way. It's a nerve-wracking moment. I can tell you right now, waiting for the jury, it's the worst feeling in the world because all you're doing is going through everything you said and everything you did. What could I have done? What should I have said? The longer they stay out, the more you have more time to think about it. Luckily, hopefully Georgia's got people around her. Hopefully he's not with his client because his client's in custody. I don't know who Dan's with, maybe co-counsel.
And Tim, the longer we go here, the better it is for the defense. Is that the general rule?
Sometimes, but not necessarily because you got some tapes. They may want to play or listen to tapes. And it's a murder case and it may take a while. They're going to try to get it right.
I'm glad to hear that. You've got to have faith in the jury system. Someone's asking how old Don and Harvey is. Harvey, I think, is about to turn 80. I want to say getting close to 80.
Probably close.
And Donna's in her 70s. Beach Sanity says Tim has done a fantastic job. Now he has to come on for Wendy and Donna's trial. We'll see what happens there. But we are on a verdict watch right now. We have a live show, 5 p.m. Eastern Standard Time. Follow us at Podcast STS on Twitter, at Podcast STS. If we get a verdict before then, we'll tweet it out and give you a heads up. And we will do that at Surviving the Survivor on Instagram, at Surviving the Survivor on Instagram, at Podcast STS on Twitter. He's 79. Of his 70th birthday was 7/20/14. Thank you for that. So 79 years old. Donna in her 70s, I believe. Tim Jansen, thank you so much for all of this. We will regroup at 5 p.m. unless we get a verdict before then. I will touch base with you in a few moments. Until then, love you, America. Love you, Tallahassee, Florida, and everywhere near and far in between.